Please, my lord.
Yes.
Lord, I beg to mention a matter for listing on any convenient date, my lord.
Any listing matters, please give it to him. If you want it today, then only make a mention.
May I please, Your Lordship?
Month of February.
Lordship, I beg to mention item number 2 of today's list. Lordship, in connection to this matter, an affidavit, additional affidavit has been filed. The same
Get it on
time-
record. Get it on record.
Lordship,
Call for it.
Item number 7 and 8 of today's list, my lord. Both these matters have become infectious.
Item number
7 and 8.
That Anganwadi worker and
Correct.
terminated.
Already retired, my lord.
Both have
Both,
retired.
both.
And they have continued in terms of the orders of this.
Correct, my lord, correct.
On the prayer of Mr. A.K. Borua, Learned Counsel for the petitioners, who submits that the cause of action as in the present proceedings, in the present case, does not exist inasmuch as the petitioner, in the meanwhile, during pendency of the proceedings, has retired from her services on reaching the age of superannuation. Accordingly, the writ petition stands. Next line, accordingly, the writ petition stands dismissed as having become infractious. 7, 8, same order.
Obliged.
may it please, Your Lordship? Lordship, I beg to mention item number 14, the arguing counsel in this,
Okay, you have given a slip
we
yesterday
have given.
on the prayer made on behalf of Mr. P.D. Nair. List this matter again. When can we have it?
Lordship, any date after 12th of February?
We'll have it on 15th, 15 to 2020.
Highly obliged.
23, 2013 matter, we'll
Yes,
finish it on that day.
Highly obliged.
Yes.
My lord, matter for listing urgent, my lord, teachers stat union on 29th, my lord.
What is the issue?
My lord, it's what has happened, the teachers stat union, they have been given a letter has been issued to them that by 30th of January, they have to exercise an option either to remain as contractual teachers in the pay scale that they're getting right now, or regularization of their service from initial date, and the proposed date of joining is yet to be decided. And that has to exercise by 30th.
Exercise your option.
So, my lord, if that option is exercised, then we will be at a loss because we cannot even give it's in the order, it's clearly been mentioned. 29th, my lord. What's all those?
May please, Your Lordship.
Yes.
I beg to mention item number 30, my lord. Matter may pass over for the day, my lord. I will file the affidavit.
It's a part-heard matter, Mr. What was the issue here?
My lord, after 2 weeks,
No, what was the issue?
my lord,
Issue. What was the case of?
yes, my lord, I have been, matter, I have not, actually, I have not gone through the matter, my lord. Actually, this is the matter of the another advocate, my lord.
Somebody had argued this matter on the other day. You have any other work today? Are you free?
No, my lord.
Can you just wait for some time? We will take this up. We'll see if something is to be done, we will do it. Or we'll have it on 1st of February. You do whatever is to be done. On the prayer made on behalf of, what,
SB Sogri.
Huh?
I on behalf of the SB Sogri.
your name? You are not in the case.
My name is A. Ahmed.
On a prayer made on behalf of Ms. MS SB Chaudhary, on account of personal inconvenience, list this matter again on 1/2/2024. On that day, whatever you have to do, you do, because we have already heard the matter. I remember. We will proceed with the matter. Yes.
May it be please, Your Lordship, I beg to mention item number 20, Lordship. Matter may be adjourned for 2 weeks.
No. This was argued. We had only placed this matter today for a clarification. You give that clarification today. 2023 matter. Okay.
20, item
Okay. 20.
20,
Okay. When you want it?
after 2 weeks, Lordship.
List this matter again on 30/2/2024. On the prayer made on behalf of Ms. MS K. Devi.
May please, Your Lordship. Your Lordship, I beg to mention 2 items, Your Lordship. One is for Upel and another is listing, Your Lordship. I don't.
May it please your lordship. Lordship, I would like to mention item number 36.
of today's list, Lordship.
36.
Yes, Lordship.
You are given a notice today.
Yes.
Okay. This prayer is made on behalf of
R taken, R Mozumdar, sorry,
H.
H. Vage Burwa, Lordship.
On a prayer made on behalf of Mr. H. Page Burwa. Is this matter again? On when do you want it?
After some time, Lordship, 3 weeks.
21 to 2024.
Much of it.
May I please, your Lordship?
Oh.
Lordship, item number 60 is a motion matter, but wrongly listed in orders column, my lord. Lordship, this is matters pertains to examination in an MBBS course, my lord. Lordship, can it be
Okay,
taken up?
after the motion
After
items,
the
item
motion.
number 60 after the motion item.
Oblige, your Lordship.
Yes, Mr. Hussain.
Your Lordship, my lord, item number, my lord, 26, I filed the state vacating petition and my lord, I will, due to my lord, this another,
Let it be called, let it be called.
my lord, this another matter, hearing matter in another court, my lord.
So you keep somebody here.
If possible, my lord,
You keep somebody here. We will not pass adverse orders. Keep somebody here. Anyone you keep it here, we'll
my
take
lord,
care.
I am,
Because the petitioner is not here. You have talked to the petitioner.
my lord, I.
Then why are you making a mention?
Communicate
He'll
first.
come and then make a prayer that he was not given. So let the matter called up. They called it. I know it's come for the first time.
My lord,
I know
that
that.
time I will leave the another court, my lord.
It has come for the first time. I know that. I'm aware of that. Hey. What's this? No, it's automatic.
মই কালি ফটকে বিচাৰিব নোৱাৰো এইটো ফাইলটো দিয়ে
Automatic.
ফাইলটো চিঠি লিখা ইনচাৰ্ট কৰা না এটা ফাইল বনোৱা
Top of the list matter, item 62.
That is ready.
Well, I would like to make a clarification.
Yes.
The argument made at the 56C has been deleted. It may be very attractive,
It's not.
at the same time, the 56 is deleted from the central.
I know, I've examined that. I went back and then examined it and I come to that conclusion, same conclusion. Mr. Gogoi, that 56C is not deleted from our state FRSR. It is deleted in the central FRSR.
otherwise Lordship, the book
That
says
books
that-
you have given, I think is central, not the state.
no, its book says that
Because what examination, senior is also saying that, and I also examined that. And I also came to that.
FIR কি জানা না দুটো কিতাব লয় না
Anything more, Mr. Vatsari?
লয় না লিখুন
Would your worship like to see that?
Give me an FRSR. You have a book, Mr. Latest book?
দুটো পেজ দেখো
That 98 notification, Mr. Gogoi, have you been able to trace?
Lordship may immediately section part 2 Lordship, it's written as Lordship. Made by the Governor of Assam under section 124(3)(b). It is
41.
Government of India Act 1935. It is there Lordship.
Under section 241(2). 35.
আমার FRSR.
It is. Otherwise also Lordship. It's a rules made under the Lordship. Section.
No, we are not on that. Whether the state rules have, the state FRSR has been amended, that is the only thing we want to do.
But Lordship, the fundamental rules that is. It is reflected that books also Lordship. It is made by.
But Mr.
ক'বলৈ একো নাই বুলি ক'ব।
Gogoi,
Lordship.
this is deleted by GSR. We don't issue GSR here, the state.
Now, otherwise also Lordship, the state follow the that one Lordship.
No, no, no.
And rule itself, the act itself,
I have some confusion here
Lordship.
because the
When
book
there
that I
is a
consulted.
confusion, even Lordship,
56C
suppose,
forget
suppose
suppose.
Lordship, it was not deleted. Today we admit that it was not deleted. Whether 1984 office memorandum can override that part, Lordship?
Yes, can, because that is an amendment to the FRSR and that is the system your government follows,
Lordship.
unfortunately. That argument is not before you, Mr.
Lordship.
You find out one amendment of the FRSR,
Lordship.
which is not issued in the manner in which 84 is issued. I'll change my view.
Lordship.
We'll just have, here, Mr. Bachchaji. Yes, Mr. Bachchaji.
And
Otherwise, Lordship, book itself says that.
I know that there's
That
some
book is
confusion
separate.
because the deletion is made by a GSR. GSR are normally by the
I
central
have
government.
no issue, Lordship. Book says that which books was followed by
No,
the.
I got it. I got it.
If
This
there
is
is
also the
something is
state.
wrong, then Lordship may put it to the registry, Lordship. The publication department has to clarify it, Lordship. Otherwise, Lordship,
We'll
some
work out. We'll
confusion
work
is
out.
there.
You have
Lordship.
your seat. We'll work out. Yes, Mr. Bachchaji.
the government of Assam has issued a clarification and acted on this, see, till 1920, till today.
I know that. That's why I had a confusion. That's why I went back and I made a examination.
I have annexed it in a written argument.
So we have submitted our written argument.
Yes, yes.
We have submitted our written argument.
Because this GSR normally is issued by the central government.
And if your lordship says that this is applicable, the GSR, to officers categorized in A and B.
No.
We don't have category of A and B.
That is central government.
Yes.
GSR is central government.
Ours is class 1, class 2, class.
Because if you come to the book, the amendments you will find all substituted clause A wide notification number, a notification is issued. The GSR is not issued. Yes, Mr. You are pointing out something.
Your lordship may come, the enclosures,
Hmm.
the written argument.
After the end of the written argument.
Your lordship got it.
I got it. I myself had filed cases in, I think, 21, 22, invoking this. That's why yesterday I went back, that day I went back and I made my, to the extent possible, I researched, but I never found any notification. Then it stuck me GSR. That's why I kept it there then.
Actually, I was thinking that how the fundamental rules SR comes to the state books. 1935 Act,
Act.
first 1922, 1935 Act, and government of Assam have done it in
Adopted.
44,
Adopted.
1940.
And
1940.
in the pension rules and the, what you call that, this FRSR, any amendment is made. It is not made as a rule. It is made by way of a notification.
Yes,
And in the bottom, you will find a paragraph that this will have an effect of substituting the
Yes.
relevant provision of the pension rules, also same, here also same. And that's the norm they follow.
and
I got it.
without that verification to the AG, 19 August 2011.
Hmm.
In inviting reference to the letter cited above, I am directed to state that the government of India has given the benefit of full pension admissibility on minimum of qualification of 20 years. Therefore, 5 years weightage benefit is unnecessary. But in case of state government employees, proportionate pension shall be allowed on voluntary retirement for 20 years service and not full pension like government. Further, the state government has already made a policy decision by sub-rule sub-para 9 of para 33 titled Pension and Other Retirement Benefits in the resolution on the report of the Assam Pay Commission. 2008. And the report of the committee issued under notification so and so to the effect that all uncovered aspects relating to the superannuation pension and other retirement benefits inter alia, unless specified in the said notification, shall be dealt with in accordance with the existing provision. Hence, the existing weightage benefit to 5 years, which was granted under so and so memo 12/84 shall continue.
Got it, Mr. Achal.
84 will continue.
This is what I was referring to, this prescription in
Yes,
the
that
pay
day
rules that day.
Then below next page. That the 1920,
This has been extended to
Governor
one
Goswami.
Prashanta Goswami.
Prasanto Goswami edition Kamaldo to go on voluntary retirement under the provisions of FR 56C of FRSR, read with Finance Department Office, memorandum number so and so, with effect from the date of handing over charge and the prospective date.
I got it, Mr. Mr. Vatsaji, one thing, if I initially first, what I propose is I'll examine the disciplinary proceedings. I'll not go into your voluntary retirement application, subject to what you say. If I come to a conclusion that the proceedings per se is not sustainable, I'll be left with no other alternative but to set it aside. And then what conclusions I come. If I decide the case on that count, then you are continuing in your services. I'll not go into your voluntary retirement.
Only thing, my lord, your lordship will mention that.
I'll do
Yeah.
that. I'll do that. And in the event I decide against you if I come to a conclusion that yes, the proceedings were correct, then only I will consider your voluntary
I
retirement.
was telling my juniors yesterday, either way, I'm not prejudiced
You're not prejudiced.
because I'll be retiring next day.
Next week. So first I'll examine the proceedings and thereafter, because they have taken a plea because of the proceedings, you have not been allowed to go.
Yeah.
I'll take that. And if I
No,
come
because
to a
I go to this extent. Even today, government can say that we are accepting your voluntary,
they can.
if they do.
And if I come to a conclusion, maybe I will prevent them from doing that. I'll deem that you are in service. If I come to that conclusion, if I find that the proceedings have not been done in the manner required, I may come to that conclusion.
Miller, next page, I've given the decisions. related.
Yes, I've seen it, Mr. Bachchan.
Then Miller, regarding back wages. Should I read this decision? Miller?
Seriatim D. That we will decide to do.
All other decision Miller we have given,
Yeah, we have given me
except
copies.
the,
Except the packages judgment.
You can give a compilation on that.
Miller, this 1973 4 SCC decision
Hmm.
is a constitutional bench decision, including some of the matters related to England and USA. Paragraph 56, the lordship will find
Hmm.
that what is the effect of overruling a decision made by the, because on that ground, my lord, there are many decision after amendment of 311.
You are
300
referring to Karunakaran. Karunakaran.
311, after it was, this is,
Hmm.
so for 311, it is that reasonable opportunity is a part of the principle of natural justice.
Fine. I got your point.
So that,
But the formulation that I have made till now, we may not be required till now, subject to correction. We may not be required to go into B. Karunakaran because the materials available on record demonstrates.
Miller,
That-
to be safe, to be on the safe side.
I got it. I got it.
This is my third,
I got it.
because many courts and even many lawyers have an idea that since 311 gone, Miller,
Natural justice is not to be full.
this Shillong IMS
Hmm. Okay. Hmm.
has been committing that mistake all the time.
I know.
Independent of it, the 311, this has to be put in.
I was dealing with a matter on the other day, I think Guwahati University matter. Therein, they had asked the person to go, no inquiry, nothing. And even in the pleadings, which I scanned as far as possible, I did not find even a whisper that they had referred to that 311 proviso, that reasonably not practicable. During the course of the argument, that point was raised, that we need not. We have power under 311, we need not, and that is gone. So I did not say anything. I just asked the council to get the records. And now I think around 2 days have gone, the records have not come. I only asked him from the records, you just show me that you had come to a conclusion that reasonably not practicable. I said, I will come in your will. It's not there. That concept, what you said is correct. People have the impression that we can do anything now. But that's not the intention. Hope there is anything more.
Your Lordship, the other day pointed out that somewhere they said that since departmental proceeding they will be taken, that's why the voluntary retirement application is not being considered.
That is in the appeal.
Appeal. But these things, they do not say anything. 56C and all.
That's an argument. We'll hold it that it's a legal argument developed by thing, but in the pleadings, it's not there. Pleadings, no. In the
No,
proceedings,
it-
it's not there. Even in the appellate order, it's not there. I got it. It's always a pleasure to have you.
No, not only that, I have considered certain things. I have a grave doubt whether the government, that means the IAS and SCS officer, whether they are at all aware of there is a fundamental SR rules by the government of India. Everywhere they do not mention, they must mention FR and SR Assam.
Hmm.
Otherwise, we will confuse.
And they can't go beyond that. They will
No,
have
no.
to follow FRSR Assam.
If Miller Assam rules were not there and this was not adopted, then this argument
Aha.
definitely.
But we have a specific rule and
Yes.
Mr. Doctor can show Mr. Vatsaji, if you go through
No.
the pages, wherever there is an amendment, it's a notification.
And your lordship say regarding the pay commission, this letter said, each pay commission report, they have a take resolution on that.
I had that, a compilation on that, but I was searching for that in my chamber. When they shifted out the files, I think that has also, a whole bunch has gone. On this, I had a specific compilation. Unfortunately, I have not been able to trace it out. Anyway, we'll have it. We'll pass the orders. Heard Mr. A.K. Bhattacharjee, Learned Senior Counsel, assisted by Mr. S. Doctor, for the petitioner. Heard Mr. K. Gogoi, Learned Standing Counsel, Higher Education Department, for the authorities, for the respondents. Number 1, 2, 3, 4, and 5. For all the for respondents number 2, 3, 4, and 5. Also heard Mr. G. Pegu for the respondent number 1. Arguments concluded. Reserved for doesn't deserve. We'll pass orders, but give me some time. Moment I can just relax it, sort out my board, I'll pass this order.
My written
Not
argument
certainly
is part of the record.
The
18
written
arguments.
arguments have been submitted by the parties to the proceeding, and the same is kept on record. Yes. Anything more?
Nothing, I have already submitted, Lordship. I have already submitted and I am bound by that argument, advance that, Lordship. And my written argument also reflect that, Lordship, reflect that part.
Daily list for withdrawal item 1.
Yes, what happened?
Lordship petitioner is not interested, Lordship.
Why?
Lordship, reason, no.
You have to give me a reason in this case. You have presented a challenge.
Yes, Lord.
We took up that challenge and we have asked the government to give on record the materials.
Last week, Lordship petitioner instructed us, Lordship. Petitioner is not interested, Lordship petitioner want to.
On the prayer of Mr.
A. Ali Maske, Lordship.
A. Ali, you are there in the case.
Yes, Lordship.
Mr. A. Ali SK, and counsel for the petitioner submits that he has been instructed by the petitioner not to press this matter any further. So in view of this above position, this writ petition stands dismissed on withdrawal.
Obliged, Lordship.
Item number 2, top of the list matter.
That affidavit has come on record?
Yes.
Good. Okay.
Para 3 and 9 is very important, my lord. This
What have you brought on record by this?
my lord, only may I submit that I am not keeping very well today.
We'll have it on some other.
No, my lord, she will let us.
Okay. Welcome. Yes, madam.
May I please, Your Lordship? Lordship, only facts which we wanted to bring on record was that the appointment of Miss Pallavi Hazarika, who had been accommodated against that post which was assured to the petitioner, Lordship. And thereafter, again, a post that has been imported is vacant for the time being, Lordship.
That is that Minoti Khan's post.
Lordship, that was vacant, which was assured to the petitioner, Lordship.
Okay, now which is the post vacant now?
That's in the political science department.
Where? Where have you mentioned?
Same college, Lordship.
Where have you mentioned that?
Lordship, in the para 11, second subpara. Lordship, the post which was assured to the petitioner in the year 2002, it was advertised and
Filled up.
Miss one Pallavi Hazarika was appointed.
She is not before us, so we'll not go into that as well.
Lordship.
Yes, madam.
Uh,
What is the
I
position with regard to
just-
this post?
I received this affidavit just now, Lordship.
You can have that instruction, please. With regard to page 11, page 7 of that affidavit now. Last paragraph.
The matter may come first week of February.
No, I'll place it, but you just see what you have to get. Page 7. Have you got page 7? Come to the last paragraph. Just have an instruction whether this post is vacant till now. Right?
Lordship.
Have that. Make a note of that. On the today, when the matter of today, the counsel for the petitioner has filed an additional affidavit and has brought on record and has therein stated that as on date, there is a post lying vacant in the political science department of the respondent college, which can be utilized to accommodate the services of the petitioner in terms of the earlier directions of this code. Miss, your name, madam?
Joya.
M. Sharma.
Huh?
M. Sharma.
M. Sharma, Miss M. Sharma, learned counsel for the college, shall verify the said position and apprise this court as to whether, in fact, the post is still lying vacant. List this matter again on 6/2/2024. 6/2/20. On that day, with that instructions, we will take a call.
Lordship, I have also handed over the advertisement, it was actually posted in their website for that political science department post, Lordship.
Earlier,
No, 2022, which is still vacant, Lordship.
that has not been filled up.
No, one post is still lying vacant.
No, has the selection been held against that post?
Two, yes, Lordship, but still three posts have been advertised, out of which one post is still lying vacant as it has.
There was
been
no
informed.
selection for that
No,
post.
no.
You get the whole instruction.
God bless.
What? Night, Kunu nai, Roy's up to night. Really?
Item 3,
Lordship, may I kindly pass over this matter for timing?
item 4,
You are the amicus.
Lordship.
Yes. Where are the records?
My lord, I am appearing on behalf of Beach Chaudhary, my lord. My lord, we have filed our affidavit, my lord, but we need some time to reconstruct our file, my lord.
You take my file. This 2013 matters, we are not going to have to. Where are the records? Last date? Where is Mr. Dhar? Yes, Mr. Dhar. You were asked in this matter last time. You were made the standing counsel of. Your name is there in the cause list. You were asked to get the records.
I think, my lord, here, B. Chaudhary, the standing counsel.
I know that he was not there, so the court had requested you. 8/8/2023. I think a copy of the order was also given to you. Yes, what did you find, Mr. Sharma? Yes, you have also received the copy of the order.
Lordship.
My lord, maybe I must have communicated, my lord. The thing is
Okay,
that
take your seat. Yes, Mr. Sharma, what do you get here?
Lordship, this is a case where petitioner has appointed as a PO. Lordship, kind of sit and issue.
Tell me any illegality in the proceedings? Do you
Lordship,
find any illegality in the proceedings?
Lordship, only thing is petitioner is a grade for employee, Lordship. And he was asked to appear before the inquiry officer. And he appeared as they have finally affidavit government. Lordship, but he was not allowed to examine the witnesses, Lordship.
No, there is a statement in the, if you come to the affidavit,
Lordship.
that there he was permitted and he had signed. On his cases, that the witnesses were taken behind my back. I was not
Lordship.
present.
Lordship,
And two, that he was not permitted to cross-examine.
Lordship.
Both these aspects have been dealt with in the reply.
Lordship, I kindly see the annexure C, page 18. That is the so-called notice, Lordship.
Of the writ petition.
Lordship.
Yes.
Page 19, Lordship.
Hmm.
Last paragraph. Your written statement stating as a whether your desire to be heard in person should be submitted to undersigned within period specified above.
That's.
List of documents and list of witnesses are enclosed in annexure A and B respectively.
Hmm.
But Lordship, may kindly see the below annexure A, that is list of documents, a Xerox copy of challan as specified, Xerox copy of written complaint and the Xerox of the challan they have submitted,
Hmm.
but not the list of witnesses and the what witnesses have stated. Their statement that.
No, that will not come in the, there. It will come subsequently to page 27. This is the inquiry report.
Lordship.
Here, it would be there. Now, if you come to that, say, second paragraph, third, after the names have been given there,
Lordship. May I read, Lordship?
no, come to the 11th line of that.
Lordship. He also admitted.
Hmm.
He also admitted that he did not deposit the said amount in designated bank and submitted for challan in Lordship.
So and so. So there is an admission there.
Lordship.
Then you will find, if you can come to, his written statement is there.
He has filed a written statement.
Thereafter, he was given that inquiry report.
Lordship,
He has filed his reply
Lordship,
and the impugned order is at page 39.
Lordship. He was
You
dismissed
come
from
to
the
page
service.
40. Third paragraph.
Lordship. In view of,
Third paragraph, no. Page 40,
sorry, Lordship.
third paragraph, 1, 2, 3,
Lordship,
fourth line. The witness,
Lordship.
read that. The witnesses and
witnesses
Sri
and,
Pallab
Sri
Chaudhary
Pallab
were
Chaudhary-
cross-examined.
Lordship,
Oral evidences were taken. The proceedings were recorded in writing and was signed by both the witnesses and the delinquent,
Lordship,
admitted to have accepted money. Now, if you go to the writ petition, you will not find even a paragraph, even a line
Lordship,
contradicting this.
Lordship. Only thing is, Lordship, after this order, petitioner has filed an appeal before the appeal.
That is not
That is-
been considered.
But there is no outcome of the appeal, Lordship. Whether the appeal is disposed of or not, Lordship, that
Where is Mr. Chaudhary?
Lord, he has got some fixed medical appointments.
Hmm?
He has got some fixed medical appointments,
Today.
my lord.
Anything more, Mr. Sharma here? You have found? Nothing.
only thing say appeal is filed, that whether they have disposed it of or not, Lordship.
2012.
If that instruction they can,
If it is gone, it's gone. Do one thing. This is your Superintendent of Taxes, Dhemaji. You are in the department. Are you a standing counsel?
no, appearing on this behalf.
We'll have this matter on 29th, top of list. Get me this instruction, whether this appeal has been disposed of or not.
Yes.
Okay? Mr. Sharma, if you can find out something more, let me know.
Lordship.
List this matter on 29/1/2024, on which the Leland Standing Council, Finance, Taxation Department shall apprise this court as to whether the appeal referred by the petitioner on 30/10/2012 has been disposed of. And if so, the order thereof. If so, as to the result. We'll have it on 29. We'll have it in the top of the list. Okay.
Apply, Lordship.
Item 5,
Yes, Mr. Bora.
Lordship, I am appearing on behalf of Mr. R.K. Dev Chaudhary. He is on legs in court number 7.
Fine. Nothing, no, but what is? Oh, that case.
I'm
But
not,
tell me one thing.
I'm not in this.
Forget
case.
it. Forget it. Forget it. As a counsel, you tell. me.
Yes,
If appellate authority wants to enhance the penalty, is not a notice required.
yes, required.
That's the only issue here. Call Mr. R.K.D. Chaudhary. Timely.
item 6,
May it please the Lordship. Lordship, in this matter, I'm submitting on behalf of S.C. Biswas as he is on bereavement.
Yeah?
As he is on bereavement.
What happened? Somebody.
Yes, Lordship.
When he will be attending court?
Not today, Lordship.
Next
He's
week?
in Tejpur actually, so he might come tomorrow.
No problem.
Yeah.
We'll have it on first.
29th, Lordship.
29th you want it? Okay. It is stated that Mr. S.C. Biswas, advocate, learned counsel for the petitioner is in bereavement. Accordingly, this matter again on 29/1/20. Hey, good.
Much obliged.
Fine to us, no problem.
item 9,
May it be the loss.
Hmm,
My lord, my humble submission is that my lord may be taken on Monday, my lord.
no,
My
today.
lord,
This matter is nothing. You go proceed. I am ready. You proceed. Bereavement, I fixed it in Monday.
my lord, old matter, my lord. we could not
Ah,
communicate
fine.
with the-
You don't know. I know what it is. I can proceed. You tell me what you have to tell me. You have the file.
my lord. I'm
Then we-
satisfied,
then-
but
then-
we
then-
could not communicate with my client, my lord.
Forget your communication with the client. Your client communication had occasioned in 2013. There is nothing here. Just answer one query. Come to page 32. Page 32. Got it?
My lord,
Right?
my lord.
Read this. After this, if you can say that there is something in this case, submit. I'll take it up after some time. Mr. Bora, the authorities had passed orders. He put it to challenge before this court. This court negated it. Now, how can he have a fresh proceeding?
Exactly.
We'll have it after the top of the list matters. I'll call it after the top of the list matters.
Item 10,
Please, your lord, the matter may be passed over for time.
Lordship,
No, she's,
Second, lordship.
your lordship, I just have one simple prayer. We don't have a record of brief of
you can take the second copy.
the second file. The first file itself contains both the affidavits. Two copies, two sets of the.
Bulai diyo, beta. Second copy. He'll give you a copy.
item 11,
Please, your lordship. First, kindly take this matter after some time.
After some.
item 12 and 13,
Mr. Moto, you are appearing for whom?
FPSC, my lord.
Huh? APSC.
FPSC, my lord, because probably sanction was given by the FPSC.
He is not here even on the last occasion.
Last occasion also.
1 lakh recovery. Recovery of rupees 1 lakh.
1 lakh.
And that is in terms of the orders in the, I don't find anything erroneous here. Only thing, page 87 is the order. Issue. I think he is satisfied.
Probably. Last occasion also probably.
No, nobody was there.
Yes, 87.
None appears on the, on behalf of the petition. I have seen it. The order is justified, according to me.
My lord.
If they could have shown something, so I'll not dismiss it on merit. We'll keep it,
My lord.
we'll dismiss on default. None appears on, none appears for the petitioner on call. It is seen from the order sheet that on an earlier occasion, that on the last date of listing also, none had appeared on behalf of the petitioner. So in that view of the matter, the writ petition stands dismissed on account of, dismissed for non-prosecution. Same order in 3591. 3503 and 3591, 12 and 13. Same order, dismissed.
Developed.
But 415 I'll sign.
But
If they come in between, we'll trouble you.
item 15,
Please, your lordship, I am appearing on behalf of D Thakur. We have instruction not to press the matter, your lordship.
It is that SC, ST.
My lord, ST,
Ah.
my lord.
Unnecessarily keeping
My
these
lord,
matters
it's kept
pending
pending
for
for
support.
2013.
On
my
the
lord.
prayer of Mr. Miss
A Borwa.
A. Borua, you are appearing for Mr. D. Thakur, learned counsel for the petitioner, submits that the petitioner desires not to press the matter any further. Post of accordingly, the writ petition stands dismissed as not pressed.
My lord, I am B Sharma for
Ah,
CGC, my
here,
lord.
Mr. B. Sharma,
CGC, my lord.
CGC.
For
Nice
the-
affidavit filed.
My lord, my lord.
SSC affidavit.
Obliged.
Okay.
item 16,
Wait, please, your lordship, Bhuvendra is on legs. Kindly pass over for time being.
Time being.
Obliged.
Itu dah ambil. The top of the list, we check for you. 17%.
Item 17.
Yes, Mr. Bhuyan, what to do?
My lord, I have made a submission which in fact was not correct on the last occasion. But I have verified the part of the notification which was not made that the service tenure of a, my lord.
That is the one understood.
Yes, my lord, 3 years.
I
that has
got
been
it.
Interfered with. So, my lord,
Now, what about the other heirs in the family?
no, my lord, this sister, only the unmarried daughter has, my lord has already taken up that matter. So, my lord, in this petition, I may be allowed to withdraw with a liberty to file a fresh, my lord, if situation demands, my lord.
No, we will have to be very specific here, Mr.
My lord, some pleadings is required in this petition
But-
also.
But
That liberty may be kindly be
I
provided.
can give you a liberty, but for fresh cause of action.
My lord, on merit, it can be decided, my lord.
We'll decide.
If I file a fresh, my lord.
Mr. Bhuyan has clarified that the submission made by him on the last date that the scheme has been interfered with was on a misconception. Actually, it is only a clause of the said scheme which was
My lord.
interfered with and proceedings thereon pending before the division bench of this court. Full stop. Mr. Bhuyan submits that he be permitted to withdraw the present writ petition on account of he may be permitted. But Mr. Bhuyan submits that he is under instructions from the petitioner
My lord.
to not press the present petition with liberty to refile if occasion so arises. Full stop. The above prayer is accepted. The writ petition stands dismissed on withdrawal with liberty to the petitioner or any family member of the petitioner
My lord.
who may be covered by this scheme. Now, like, with liberty to the petitioner to institute fresh proceedings if the occasion so arises in future.
Obliged.
Supplementary list, item 63.
Yes, Mr. Roy.
Well, I shall be very brief because Lordship was indicating yesterday that the disagreement note 54. Yes, on the disagreement row, some documents were referred to. These documents, in fact, was not relied on. My lord, if Lordship come to page,
Please, I've got it.
only what was relied on by the
CBI report.
CBI report, right?
Where is that CBI report in the in the list?
I'm coming to that, my lord. My lord, it happened like that. The petitioner, my lord, after the the documents were given to him, they were relied on in the charges, while framing the charges. He has himself wanted certain documents. He can under the regulations. And in that,
This document was given to him.
Lordship will kindly have a look at page 150, page 51. These are the documents he wanted.
Okay.
And page 53 down,
Hmm.
last one,
Hmm.
My lord has found page 53.
Hmm.
Last findings of the CBI case number are 5.
Hmm.
This is one. Now, my lord will kindly come to page 82.
Hmm.
82 onwards.
Hmm.
82, my lord will kindly see date. This is the daily order sheet. Date 25/2. At the outset, PO was directed to hand over all the documents received from the ZO as requested by letter dated so and so, or otherwise give certificate or defense documents.
No, I got it. What is that you are trying to point out?
My lord, the documents he wanted were given to him. Number one. Secondly, the IO also said, if you are not given any document, kindly give me the list. In the order sheet, the lordship will find. And he has not given any list showing this document was not furnished to me. There is a specific order by the IO. Say, if you were still not given a document, you give me the list. And he has not given it. Now, my lord, if lordship kindly have a look, because after the inquiry report was given to the disciplinary authority found part of the charge number 2 is proved. There is no dispute on that. As the charge number 3, the materials were there during the inquiry. Every material is there, only the inquiry officer did not consider those materials. The disciplinary authority is well within its right
Got it, Mr.
to look into all the materials available to him and pass order. This is, my lord, I can, if the lordship kindly permit me, I can hand up to the.
Do one thing. Give me a small note
My
on
lord,
your this submission. Give me a small note on your this submission
that I'll give it, my lord, I can.
by Monday. We're
By
fixing it
Monday.
on Monday.
Along with that, I'll show
You-
you.
you
That's
give it.
better, my lord.
This is the only point you have.
The lordship, this is the
Only point I have to
Right,
consider.
exactly.
Mr. Chauhan, we'll consider that. Yes, madam.
Deep level.
Anything more to say? After I have already,
My lord, I am relying on two judgment of Honorable Supreme.
you also give me a small note
Yes.
with that.
Yes, ma'am.
List this matter again on 1/2/2024,
Lordship. But
on which date the parties shall shall submit their respective written arguments along with the case laws they wish to discuss. Mr. P.K. Roy shall also provide to the court a copy of the regulations, relevant portion of the regulations,
lordship,
that disagreement note.
exactly. I'll do that.
Only that relevant portion of the regulations of FCI relevant to the case. And 1/2.
Lordship.
Item 64.
Who is appearing for the APGCL?
Just standing on.
Can you just ask him to come?
Item number 6.
এটু মাটি দিয়ক 65 টু মাটি দিয়ক না 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 তোৰ ভুলকে দিছে এইটো। Mr. Gogoi is here. Mr. Fukan, can you just have Mr. Gogoi? Hey, Gogoi.
Item 65.
Lordship, in this writ petition, Lordship, in a pick and choose manner, the department has.
Yes, I wanted that instructions here. They have not filed an affidavit also.
They did not file affidavit in terms.
Can you just call Mr. Gogoi? Yes, Mr. Das. That affidavit is not filed, your officer should be here. 2 o'clock.
Matter is able to fix at 2, my lord.
No, no, no.
We have communicated with the secretary, my lord. First, I think he will be present, my lord.
Okay.
At 2.
No affidavit will be filed.
No.
He'll be present. 2 o'clock.
Obliged.
Daily list for motion, item 18.
My lord, this letter record was called for lordship. That pertains to compulsory report, my lordship.
Who is appearing for the government? Where's Mr. P. Soikia? 2 dates we have given time, Mr. D.D., Ms. D.D. Burman, and then Mr. P. Soikia. Have instructions? Yes. Mr. Gogoi, that matter, your secretary is coming at 2 p.m. You have not filed an affidavit.
Lordship, because the file we are not traceable, so he will come, he will severely ill, otherwise also as per lordship's direction, he will come.
Okay,
It's an eye infection, even he is a bedridden, he will come.
let him come.
Personal appointment.
What is this, Mr. Soikia? I have not been able to make a head of tail of this.
My lord.
His case was considered. Okay. What is the name of the petitioner here?
My lord.
Mahesh Kumar Boro.
Kumar Boro, lordship.
Okay. That application of yours purportedly submitted on 25/5/2017 is not on record. Your application is of 16/11/2022. That was considered and it was rejected on 30/12/2022.
16/11/2022.
22. And thereafter, subsequent application 28/8/2023.
But regarding that application, I have no any instruction. lordship.
You may not happy. We have the order. Your case is that it was not considered.
Fine.
It is considered. Finished. End of the matter.
But wrong date, lordship, my lord.
Heard Mr. Team here, learned counsel for the petitioner. Also heard Mr. P. Soikia,
1 and 3.
learned government advocate, learned government advocate representing
1 and 3, my lord.
1 and 3. Also heard Mr. A. Fukan for respondent number 2, 4, 2 and 4. In terms of the order dated, in terms of the orders passed in this proceeding, Mr. P. Soikia has produced instructions which reveals that the case of the petitioner was considered by the district level committee and the same was rejected on account of the fact that the applications for appointment on compassionate grounds were not filed within the time limit prescribed. Full stop. The father of the petitioner, Praneshwar Boro, page 5 में while working as a teacher in SB Boro ME School, had died in harness on 17/6/2016. Full stop. It is the projected case of the petitioner that in pursuance to the death of his father, he had on 25/2017 submitted an application before the district education, elementary education officer, Themaji, praying for appointment on compassionate grounds. The said application not being considered, the petitioner had again on 23/2/2022 preferred a representation before the respondent authorities for consideration of his case. The consideration as required not being done, the present proceedings were instituted. Full stop. It is reflected from the instructions produced by Mr. P. Saika that the application as purportedly submitted by the petitioner on 25/5/2017 is not available on record. And it was concluded by the district elementary education officer Themaji, while a communication dated 30/10/2023 made to before the district commissioner Themaji that no such application was submitted by the petitioner. It is a projection of the full stop. Further, it is seen that the case of the petitioner was also placed before the district level committee, and the said committee on consideration of the matter had rejected his case as a fresh applicant, inasmuch as the application that was placed for consideration was of 16/11/22. Full stop. The said decision of the district level committee was communicated to the concerned authorities by the deputy commissioner, come chairman, district level committee, wide his or speaking order dated 30/12/2022. Full stop. The death of the father having occasioned on 17/7/2016 and the case of the petitioner in terms of the application submitted by him having been considered by the duly constituted district scrutiny committee and the same having been rejected, and there being a dispute with regard to the fact as to whether the petitioner had submitted his application on 25/2017, which is stated to be not on records of the district of the office of the district elementary education officer Themaji. A dispute arises with regard to the date of actual submission of the application of the petition. So, in view of such disputed questions of fact, and also the position as brought on record by the written instructions that the case of the petitioner was duly considered by the district scrutiny committee, there arises no further occasion to issue any direction to the respondent authorities to have the case of the petitioner reconsidered for appointment on compassionate grounds. Full stop. The father of the petitioner had expired on 17/7/2016, and by now around 7 years have passed since and thereafter around 7 years have passed, and the family of the petitioner having sustained for such long period of time, in my considered view, there is no necessity as of now to issue any direction for having the case of the petitioner considered for appointment on compassionate grounds. Full stop. Bracketed, refer that decision of the Supreme Court, Devabrata Tiwari, just the decision you write, and the paragraphs thereafter. Just quote that, give it to me. Dismissed. The written instructions produced by Mr. P. Saikya is kept on record and marked as X. Sorry, Mr. Wee.
Item 19.
Yes.
Lakship, on the last occasion, Lakship had asked me to produce record, specific instructions.
Yeah, a lot of money.
Lakship, here the petitioner has been selected and recommended for appointment as assistant teacher, Lakship, in provincial SP school under Hailakandi district And Lordship, the DLC has already sent proposal to the SLC for finalization of the case of the petition.
Lucky you. We'll close it. Let them take that final consideration. There is something to come back. Mr. A. Fukan, Learned Standing Council Elementary Education Department, in terms of the directions passed by this court on 19/1/2024, has furnished a copy of a communication dated 24/1/2024 issued by the Additional District Commissioner Education Hailakandi and District Elementary Education Hailakandi, by which issued by the so and so to the Director of Elementary Education Assam, Kailipara, wherein it has been stated that the case of the petitioner was again placed before the District Scrutiny Committee, and the said committee has recommended, the said committee in its meeting held on 19/9/2023 has recommended the case of the petitioner for appointment on compassionate grounds as assistant teacher in provincialized LP schools under Hailakandi district. Full stop. While the said communication, the copy of the minutes of the said meeting of the district level committee was placed before the Director of Elementary Education Assam for further necessary action. Stop. Subpara. In view of the said development, this petition stands disposed of, requiring the Director of Elementary Education Assam to place the case of the petition, the proposal of the district level committee, the recommendation made by the district level committee in its meeting held on 19/9/2023 in case in favor of the petitioner before the state level committee for its consideration. Full stop. The further course of action in the matter shall be so done in terms of the recommendation that be made by the state level committee. Full stop. The recommendation as made by the district level committee in favor of the petitioner be placed in the next sitting of the state level committee. Full stop. Subcar. Full stop. In the event the petitioner is aggrieved by the decision that may be arrived at in the matter on consideration of his case of the said proposal by the state level committee, he is at liberty to institute appropriate proceedings assailing the same. Full stop. With the above observations and directions, the petition stands disposed of. Copy of the communication dated 24/1/2024 along with its enclosures placed on record by Mr. A. Fukan is kept produced by Mr. A. Fukan is kept on record and marked as X. Disposed of. Type करके दे देना आपको। वो खाली आपका जो आगे वाला-
Item 21.
We have quoted that judgment, need not quote that, just refer to that. Tiwari, the case of Devobrata Tiwari was updated so reported in so and then the last, after the quoting, there are a few paragraphs, usko khali laga. Huh? Yes.
Instruction yet to receive.
Huh?
I'm yet to receive the instruction, Lordship.
Huh?
I'm yet to receive the instruction, Lordship.
Okay, your director is, your secretary higher education is coming at 2 o'clock. We'll have it at 2 o'clock. 2 o'clock he is coming, so we'll have this also.
Okay.
Mr. Gogoi. Mr. Gogoi is coming at 2. Oh.
Item 22.
Item 20, your Lordship has directed me to produce the medical report of the petitioner. There are 3 numbers. But the medical report of these particular petitioners, they are not with the department, Lordship. We have the medical report of 125 numbers of candidates who were qualified.
Okay.
They have medical report here, Lordship.
Okay. Okay.
Candidate, na?
No, I don't know.
I can furnish it. He can furnish, Lordship. It is in a
Mr. Upamanya, you furnish.
Yes, Lordship.
In terms of the order dated 12/1/2024 passed in this proceeding, Mr. Sisti has clarified that the medical examination reports of persons not found qualified in the selection process is not available with the elementary education department or secondary education department.
Yes.
And the same is with the health and family services, family welfare department of the government of Assam. Mr. D. Upamanyu, Ranit Standing Counsel, Health and Family Welfare Department, shall undertake to furnish to the counsel of the petitioner by the next date fixed the medical report of the medical examination report of the petition carried out in pursuance to the advertisement dated 25/3/2022 for recruitment to the post of class 4, to recruitment to various class 4 posts in departments and establishments of governments.
My lord, the social, in another cases, my lord, and it was informed to the court that the report has been sent to the social justice department.
He will have a copy. He will have. You get that copy.
On lordship. Second lordship.
Because why I am doing it, you will have to challenge that. I want to give
Yes,
you to
Lordship.
that so that you can challenge, because there is already a order of this court.
Yes, lordship.
The
That
moment
is
I get
passed
that
in
order,
petition.
get those reports, it will be handed over to you so that you can make a challenge to. Then we will see.
Yes, lordship.
Sir,
Lordship,
by
one
the
second.
23, 24.
Or you can have it on. Can you get it by 7th?
Second, second will be,
Second. On list again on 2/2/2024. Please try to do.
highly ordered.
My lord, 23, 24 same.
23, 24,
Yes,
same.
same.
22, 23, 24, same. Same order. Huh? 2nd of February. You do one thing, amalgamate it and pass one order. But keep a copy in each.
Apply.
या नहीं तो एक काम करो ना, ये करो, पिटिशनर होगा, तीनों एक ही ऑर्डर मार दो, ठीक है, सेपरेट ऑर्डर्स, ठीक है. Yes.
Item 25.
That matter where I was not.
Get hold of Mr. Fukan. We'll pass orders. Timing.
Highly approved.
Upgraded item 60.
Lordship, Mr. D. Gogoi has received some instruction, lordship. He is on legs, lordship. I'll inform him. Can it be taken after?
After some time, at 2 o'clock we'll have it. Mr. Das, you need not wait, at 2 o'clock. At 2 o'clock, ask Mr. Gogoi to be here.
Yes, sir.
Itu duta bazate matiri ba musume.
Item 26, order stay vacating.
Mr. Hussain had made a mention of this matter in the morning, but when he told that he had not informed you, I did not permit him. First day, we'll give him some time, give him a week's time.
Because he has filed under 226(3).
I know that. We'll give him a week's time. After that, we'll fix it and we'll hear it. We have seen your readings. If that be so, this order may not be sustainable. We'll see.
My lord.
On the prayer made on behalf of Mr. Z. Hussain, counsel for the opposite party petitioner, who prays for filing his objections against the application for vacation. Stop. List this matter again on 5/2/2024. In the meantime, the opposite party number 1 petitioner is permitted to bring on record his objections fully. If by the next day, the objections as permitted to be filed is not brought on record, the matter shall be proceeded with basing on the materials available on record.
My lord, can it be on 7, my lord?
7, no problem. 7.
I am for
7.
opposite number 1 here. He is filed interlocutory for vacating in.
Okay.
I am for it petitioner.
Oh, he has filed.
He has.
Hey, cut off the order. He gave me the impression the other way around. On the prayer made by Mr. Z. Hussain, counsel for the applicant, IMA Marega, list this matter again on 7/2/2024. In the meantime, you can file.
I have
The-
filed, my lord.
The opposite party number 1. Oblique writ petitioner is permitted to bring on record his objections by the next date fixed. Full stop. In the event such objections are not filed, the matter shall be proceeded with basing on the material 7.
My lord, I have already filed, my
May I
lord.
please, your lordship?
Objection is here on record.
I have filed on 19, my lord. 19 once.
Last line, Karthik.
On 19 I have. Anyway, my lord, it will come with.
Let it be there.
I am okay.
May I please, lordship? Lordship, item number 12 and 13, lordship, I apologize because there was some delay due to traffic, lordship. I could not appear.
Pradip Borwa, restored.
13,
It is restored.
yes,
I'll Pradip.
12 and 13,
We'll hear it.
lordship.
Ms. Sharma, Mr. Mounta, he has come, 12 and 13.
Oh, my.
We'll hear it. Yes,
Lordship.
13 matters we'll always give preference. Yes, what is your case?
Lordship, in both the cases, lordship,
One first question, have you got your pension by now?
yes. Pension we are getting,
1 lakh recovery,
1 lakh recovered,
recovered
not recovered.
Why?
Because there is a stay,
in this proceedings.
yes.
Which order?
Rule has been issued, order lordship dated.
Okay, yes, there is an order.
26.
26.
Government required.
You make your submissions with regard to the merit of the case. Your name?
P. Acharya.
P. Acharya.
Lordship, in the first item, lordship 3503,
Yes,
lordship, impugned order is at page number 87,
87.
87, lordship.
Yes,
Married lordship, the finding. The delinquent officer, Sri Pradeep Borua, the superintendent of taxes, now assistant commissioner of taxes, retired, was charged with gross negligence due to it resulting in loss of government revenue, misconduct, unbecoming of a responsible government servant, and breach of trust. The inquiry officer inquired into charges leveled against the delinquent officer, and although the charges of misconduct and breach of trust could not be proved, but the charges of negligence was duly proved, there was also loss of government revenue. So the only charge, lordship, against which the petitioner was penalized, lordship, was negligence which led to loss of government revenue. Other charges could not be proved. So this was the only charge. So if lordship comes to page number 37, lordship.
yes.
This is the notice. Page
You
number
take me to
38
the
is
show cause first. Show
show cause
cause.
notice.
Show cause.
Page number 38 is the relevant portion, lordship.
Okay,
The total tax on import of such taxable goods comes to more than 15.50 lakhs. So there is no definite amount, lordship. Calculated at different tax rates, the total purchase will be much more than the above value if the purchase of taxable goods on the remaining delivery notes issued by you to the dealer are taken into account, as the same are not available in the TIMS record. The amount of tax as shown above will be much more if calculated on the value of sale price, which includes the dealer's profit, cost of freight, etc. So, lordship, there is no definite, even in the show cause notice itself, there is no definite amount, lordship. The amount is not final, lordship.
So the charge has to be definite and distinct, Lordship. So the quantification, whatever quantification they have stated in the show cause notice, that is also not the final quantification. Charge sheet is page number 60, Lordship. Relevant portion is at page number 61. The total tax on import of such taxable goods comes to more than 15.70. More than 15.50 lakhs calculated at present tax rates, the total purchase will be much more than the above value. So there is no definite and distinct charge, Lordship. If the purchase of the remaining delivery notes issued by you to the dealer is taken into account, as the same are not available in the TIMS record, the amount of tax as shown will be much more if calculated on the value of sale price, which includes the dealer's profit, cost, freight, etc.
Okay. Then what did you do?
So quantification of loss is vague and not proper, Lordship. Our submission is quantification of loss is not proper. Without proper quantification.
But at
of
least
loss-
it is 15 lakhs. So you have been only penalized 1 lakh. We'll ask them to go up to 15 lakhs then.
Lordship. Lordship, charge has to be definite and distinct.
You come to your reply. Page 67.
And Lordship, no affidavit, counter affidavit has also been filed.
You just establish your case basing on the documents available.
Lordship.
Forget the counter affidavit.
Lordship.
So you deny all the charges.
Denied all the charges, Lordship.
What is the inquiry report?
Inquiry report is at page number 83.
Okay. Findings?
Findings, page number 85, Lordship.
85.
85.
Okay.
Third para, it appears.
Huh.
It appears that the charge of misconduct could not be proved as the DO did not defy any specific order or showed insubordination to any senior officer. There is also not enough material to prove his misconduct. He also wrote to his higher authorities about his inability to control subordinates or to replace some staff who were not obedient to him. Perhaps some action should have been initiated against those subordinates who disobeyed him. He also stated that he himself had to inquire and had to get satisfied before issue of registration to the firm in question. Similarly, the charge of breach of trust is also a general and wider term to fix responsibility on the DO, as he clearly stated that he was satisfied and hence issued the registration to Messrs. Jamuna Enterprise. He, being a competent authority, can issue if he is satisfied.
Hmm.
There is also no doubt about the fact that he was a competent authority in the instant case for both registering the firm as well as issue of delivery notes, irrespective of the number or time schedule of the letter.
Hmm. Hmm.
Then, Lordship, suddenly, in contradiction of this, page number 86. Last
No.
paragraph,
You have that last paragraph.
Lordship.
However, the DO failed
However,
to
the
define.
DO failed to define the charge of negligence of duty, neither through his statements or any supporting document. There was also loss of government revenue irrespective of its value. The DO has stated that he himself has to take the responsibility of entire inquiry, para 1 of this reply to charge number 1 of the show cause notice dated 14/11/2008. In his statement before the undersigned also, he stated similarly, but contradicted somewhat by concluding that he got himself satisfied with the information provided by the applicant with the application itself. The note sheet of the office file also shows that neither the senior assistant Sri Borkatoki nor the DO explained anything in reasonable details. That the DO was satisfied was not mentioned in his order, nor was there any mention of what made him satisfied. He kept the basis of his satisfaction to himself and did not mention it anywhere. This is not a personal or private establishment that anything can be done at an officer's will. This is a public office run by public money, and officers and staff have accountability. Any order has to be self-explanatory so that even after the concerned officer superannuation transfer or even death, the public or its successors know on what basis the actions were taken. The records must speak for themselves. In the present case, the senior assistant who wrote the dealer has applied, and the officer here is the DO, Shri Borua, ordered, asked for deposit of security money. Then the senior assistant again wrote, the dealer paid, and the officer's final order was issued TIN. There was no indication of any inquiry and even no mention of any record that has satisfied the competent authority. That was a sheer mockery of public office, and such things must not be allowed. And if these are the patterns of note sheets and orders maintained in the offices of the superintendent of taxes, then these need to be changed immediately. However, the charges on issue of large number of delivery slips to the firm seems to gain ground owing to the facts of the preceding paragraph, but there always remains some gray area to pinpoint responsibility, as an officer may issue with good intention also, and since these are linked up with gates outside his jurisdiction, plus good communication system, one can always take plea due to power failure. He can also take the benefit of doubt whether it arises owing to award conferred on him, as mentioned repeatedly in his written statements.
Okay, fine. Then the penalty order, 87.
Yes. 87 is the penalty, Lordship.
In the inquiry, no loss was quantified.
No loss was quantified.
Okay, next.
So without quantifying the loss, Lordship, the penalty was imposed. And the charges of misconduct and breach of trust also was not proved, Lordship.
Yes, who is appearing for the respondents? Mr. Monto,
So, my lord, actually, that department has to be, my lord, defend the case, my lord.
they are not there. Anyway, they are not there. None appears last time also. No. Last time Mr. Chaudhary was.
Probably they have not filed affidavit also.
They have not filed affidavit. They have done nothing. We'll proceed. Don't worry. But Mr. Monto, you may not have anything much to say.
Just, my lord, this procedure, whether there is correct or not, we have to look into that. My lord,
That you have looked into, and we'll only go into deep.
Yeah.
into it now. The petitioner. Heard Mr. B. Achaji, Learned Counsel for the petitioner. Anything more, Mr. Achaji?
No, Lordship.
This much?
In this case, nothing is there. But there
Sit
is
down.
another item.
There is what is the second case?
Second case, Lordship, impugned order is at page number 55. It's almost similar only, Lordship. Only thing is that 3 lower deduction certificates were issued because there was a notification of government which was not available in the office. So 3 lower deduction certificates were issued, and one
Where is the inquiry report here?
Lordship. Inquiry report is at page number 49, Lordship.
And the final findings?
Final findings is at page number Lordship 51. Lordship may also come to page number 50, the last para. Page number 50, Lordship.
Your inquiry officer says there is nothing to see the loss.
Regarding page number 51, last para says that regarding alleged loss of more than 11 crores as per charge. brought in
Okay,
the
fine.
paper
What is the
notice.
penalty?
Penalty, Lordship,
55.
1/3 of gross pension and 50% of remaining DCRJ.
recovery of 50% of the remaining amount of DCRG after recovery of so and so as penalty, deduction of 1/3 of gross pension so and so for a period of 3 years. Lego. Okay, take your seat. The petitioner, while serving as the heard Mr. B. Acharji, learning counsel for the petitioner, also heard Mr.
H. Burwa on.
H. Burwa for the Finance Taxation Department appearing on behalf of Mr. B. Chaudhary, and also heard Mr. T.J. Mountos, learned senior counsel, assisted by Ms. P. Sharma for the Assam Public Service Commission. Any more parties?
For respondent number 19, for respondent concern and public living.
You?
I'm for respondent number 8, Lordship, in item 12.
8 is accountant. Also heard Mr. A. Raman for the Accountant General bracketed A&E Assam, and also Mr. B. Dury, learned junior government advocate for the Pension and Public Grievances Department. Also, the petitioner, while functioning as the Assistant Commissioner of Taxes, was issued with a show cause notice dated 5/11/2008 under the provisions of Rule 9 of the Assam Services Discipline Appeal Rules 1964, leveling against him 2 allegations and thereon drawing a charge of gross negligence to duty, misconduct unbecoming of a responsible government servant, and breach of trust resulting in loss to the government revenue. Full stop. On receipt of the said show cause notice, the petitioner submitted his reply. When did you retire, Mr. Acharji?
Date of superannuation is 31/8/2010.
Full stop. Basing on the said, on receipt of the said show cause notice, the petitioner submitted his reply thereto, while his communication dated 14/11/2008 denying the charges, the allegations and the charges leveled against him in the said show cause notice. Full stop. Thereafter, on being not satisfied with the replies filed by the petitioner, an inquiry was ordered into the matter, and an inquiry officer, along with a presenting officer, came to be appointed by the disciplinary authority by a notification dated 11/2/2010. Full stop. The petitioner thereafter participated in the, what is the date of the inquiry report?
Date of the inquiry report, Lordship.
Okay, 24/6/2006. Full stop. Thereafter, the petitioner participated in the inquiry. Inquiry held. Full stop. On conclusion of the inquiry officer, while his communication dated 24/6/2010, submitted his report thereon. Full stop. The said report was furnished to the petitioner, who also submitted his representation thereon against the same. Full stop. On consideration of the representation of the petitioner, along with the inquiry report of the inquiry officer, full stop, the disciplinary authority wide order dated 25/11/2011 proceeded to dispose of the departmental proceeding by imposing a penalty of recovery of 1 lakh from the DCRG of the petitioner. Full stop. Such recovery was purportedly made on account of loss of government revenue. Full stop. It is to be noted at this stage that the petitioner on 31/8/2010, on reaching the age of superannuation, had retired from his services, and the proceedings were continued under the provisions of Rule 21 of the Assam Services bracketed Pension Rules 1969. Full stop. The show cause dated 5/11/2008 reflects that the petitioner has been charged, rightly so, for having committed gross negligence to duty, misconduct, unbecoming of a responsible government servant, and breach of trust, resulting in loss of government revenue, basing on the allegations leveled against him therein. Full stop. On a perusal of the inquiry report, it reveals that both the charges of misconduct as well as breach of trust were held to be not proved by the inquiry officer. Also, the findings relevant to the purpose as reflected in the inquiry report is extracted here in below, page 85, A to A. Also, a perusal of the said finding would reflect that the petitioner had not committed any misconduct in the matter. Full stop. It is settled law that in absence of any misconduct being alleged against a delinquent officer, no penalty is permissible to be imposed upon him. Full stop. The inquiry report further, while holding the petitioner to be guilty of willful negligence, negligence of duty, has again ordered that, has again concluded that the same may have led to certain loss of government revenue. Full stop. But what is required to be noted is that in the inquiry report, there is no quantification of any such amount that might have there is no quantification of any such amount with regard to loss occasioning to the government on account of negligence, purported negligence of duty by the petitioner. Full stop. The findings otherwise recorded with regard to negligence of duty does not inspire confidence of this court, inasmuch as the said findings are all vague and not relevant to the allegations leveled against the petition. Full stop. In view of the said findings in the inquiry report, the order dated 25/11/2011 is now to be examined. The disciplinary authority, basing on the conclusions basing on the findings arrived at by the inquiry officer in the inquiry report dated 24/6/2010, and the representation of the petitioner, had concluded that the petitioner had caused the negligence of duty on the part of the petitioner had led to loss of government revenue, and basing on this said conclusion, the deduction of ₹1 lakh was ordered from the DCRG amount of the petition. So what is to be noted here is that the disciplinary authority has not perused the inquiry report in its proper perspective, inasmuch as when it is the conclusion of the inquiry officer that there is no misconduct and or breach of trust on the part of the petitioner, mere allegation of negligence could not have been projected to impose upon him the penalty as so imposed now. Full stop. It is also to be noted that mere negligence is no misconduct in the eye of law. Full stop. What is required is gross and willful negligence. The inquiry report does not bring on record any such material which would establish any gross or willful negligence of duty on the part of the petitioner. Full stop. In the said view of the matter, the impugned order dated 25/11/2011 in the considered view of this court cannot be sustained, and accordingly the same is set aside and quashed. The petitioner shall now be refunded the amount so deducted from his DCRG in terms of the said order dated 25/11/2011. The said amount shall be refunded to the petitioner within a period of 3 months from the date of receipt of a certified copy by the certified copy of this order by the Principal Secretary to the Government of Assam, Finance Department, and the Accountant General bracketed ANE, Assam, Moidam Gaon, Assam, respondent number 8. Full stop. With the above observations, the petition stands allowed. Now, the second one.
Second one, Lordship.
Your suspension period was regularized.
Yes, yes. It was not under suspension.
He was under the suspension in the first case, I suppose.
Yes.
Huh? Nothing. Check up.
Lordship.
I think I found something somewhere. He is under suspension. Full stop. The petitioner, उसको आगे मेरे वो जो 1 lakh काट के हो गया का पीछे last में before disposal. The petitioner was placed under suspension while order dated 28/2008. Also, in view of the fact that this court has interfered with the order of penalty dated 25/11/2011, the period of suspension of the petitioner shall now be treated to be on duty, and the salaries for the of the petitioner for the said period after deducting the subsistence allowance already paid shall be refunded to the petitioner also within a period of 3 months from the date of receipt of a certified copy of this order.
Recovery part was stay for it. There is a stay order in recovery part.
Yeah, he says it has been recovered. It has been recovered. It has been paid to you. 1 lakh?
1 lakh, no.
No, it has not been paid.
That's second case.
Huh?
Second case deduction.
Deduction, that is, and here you are getting the full pension now.
Yes, deduction was
Stayed.
done. Deduction was stayed, Lordship.
Second case now.
Yes.
Second case. Thank you, Mr. Mount of order. Full stop. Likho. The petitioner, while working as, petitioner while working as Assistant Commissioner of Taxes was issued with a show cause notice. Where is that show cause notice here, Mr. Achaji? Yes. Show cause notice dated 21/10/2009. Leveling a charge of gross negligence to duty, insubordination and breach of trust resulting in loss of government revenue on the basis of the allegations set forth therein. So, the petitioner on receipt of the said show cause notice had submitted his replies denying the allegations and the charge so leveled against him by the show cause notice dated 21/10/2009. Mr. Achaji, if there is any error in the facts, just let me know.
Lordship.
Be careful.
Lordship.
Full stop. The replies as submitted by the petitioner not being found to be satisfactory. The disciplinary authority wide notification dated 18/11/2010 proceeded to appoint an inquiry officer along with a presenting officer. Proceeded to direct holding of an inquiry against the petitioner and for the said purpose appointed an inquiry officer and a presenting officer. Full stop. The petitioner participated in the inquiry, and on conclusion of the inquiry, the inquiry officer submitted his report. On what is the date of this report, Mr.?
Page 49.
There's no date here.
There is.
Submitted his report wide communication dated 23/8. No. The inquiry wide communication dated 27/6/2011. Also, the petitioner, the said inquiry report was forwarded to the petitioner, and the petitioner on 14/11/2008 submitted his written representation thereon. Full stop. Thereafter, the disciplinary authority had issued the order dated 8/10/2012, imposing the following penalties on the petitioner. A. Page 56. A2. A. Right? Full stop. It is full stop. The petitioner was charged with gross negligence to duty, insubordination, and breach of trust, which was held to have resulted in loss of common revenue. Also, the inquiry officer, in his report, after considering the materials coming on record, had categorically concluded as follows. B to B, page 51. Also, the said conclusions of the reached by the inquiry officer would reflect that although the petitioner had issued 63 numbers of lower deduction certificates, the same was subsequently cancelled by him. Further, with regard to the loss of more than 11 crores as per the charge, as per the allegations leveled against the petitioner, it is the conclusion of the inquiry officer that the same could not be examined in the inquiry in absence of any relevant records being placed. Full stop. What is reflected from the said inquiry report is that there was no material brought on record by the presenting officer towards justifying the charge against the petitioner that he had defalcated or caused loss of government revenue. He had caused that to reflect that his actions had resulted in loss of government revenue. When it is the specific conclusion that the said charge was not established in the inquiry, the disciplinary authority could not have, in the impugned order dated 8/10/2012, taken a different view in the matter and proceeded to hold that the delinquent officer was responsible for loss to the tune of rupees 11.22 crores. Also, it is to be noted here that the said conclusion reached by the disciplinary authority in the order dated 8/10/2012 is contradictory to to the findings recorded by the inquiry officer in his inquiry report. Full stop. What is to be noted here is that there is no disagreement note issued by the disciplinary authority prior to recording such contradictory view, which is in contradiction, which is contrary to the views of the inquiry officers basing on the materials available on record. In the said view of the matter, the said conclusion reached by the disciplinary authority in the order dated 8/10/2012 cannot be sustained. Full stop. Accordingly, the order dated 8/10/2012 stands interfered with. Full stop. In view of the fact that the recovery as directed by the impugned order dated 8/10/2012 was stayed in view of the interference of the full stop. It is to be noted that this court, while issuing notice in the matter, while order dated 28/6/2013, had stayed the recovery of 50% of the remaining amount from the remaining amount of the gratuity as imposed by order dated 8/10/2012. The said order is in operation till date. Accordingly, the said order is made absolute. Order till date, full stop. Now with the interference made by the order dated 8/10/2012, the recovery as well as the deduction ordered therein with regard to the gross pension of the petitioner shall also be, is no longer in existence, and accordingly the petitioner shall be entitled to the full pension that he would have been entitled to. Full stop. With the above observations and directions, the petition stands disposed of. The petition stands allowed.
Highly obliged.
No.
Yes, and motion as any. Motion to material. Madana, हम correct कर देंगे.
Timing item 25.
Lord, I have received an instruction, my lord. It has
Yes, Mr.
the special permission has been withdrawn, my lord. একটু লয়ে যাবো, চলো।
They have cancelled it. You will have to challenge this. The petitioner in the present proceedings has raised a grievance with regard to the action on the part of the college authorities of
JB Law College.
JB Law College in not permitting her.
Sorry.
You are not permitted to appear.
Permitted for the practical exam.
In not permitting her to appear in the practical examination for
10th semester, my lord.
10 semester examinations held in the month of June 2018.
My lord, August, my
In
lord.
the month,
August, month,
19,
August,
23.
19th August
19 August
19/8/23.
2023. Also, the petitioner was permitted to appear in the said examination by the controller of exams, controller of examination, Guwahati University, while an endorsement made by him in the representation of the petitioner on 16/3/2023. Also, the petitioner thereafter, faced with such situation, although with some delay, had approached this court raising a grievance with regard to the said action on the part of the college authorities of JB Law College. Also, Mr. P.J. Fukan, Learned Counsel, had on 12/1/2024 undertaken to receive instruction as to the actual facts behind the said issue and to place the same. Accordingly, the matter was directed to be listed today. Also, today, when the matter was listed, Mr. Fukan has placed on record a communication dated 19/8/2023 issued by the Controller of Examinations, Guwahati University, wherein it has been contended that
last line, my lord.
contended that the wherein it has issued brought on record a communication dated 19/8/2023 issued by the Controller of Examination, Guwahati University, to the principal JB Law College, wherein it has been contended that the permission granted to the petitioner on 16/3/2023 is hereby cancelled. The contents of the said communication being relevant to the purpose of the present matter is extracted herein below. A to A. Full stop. Full A to communication. Full stop. The case of the petitioner being solely based on the purported or upon solely based on the directions as contained in the endorsement of the control of examinations dated 16/3/2023, and the said endorsement and said permission as granted by the said endorsement having been cancelled by the same very authority, the present writ petition is not maintainable and requires to be dismissed. Full stop. Accordingly, the writ petition stands dismissed. However, liberty is granted to the petitioner to assay a communication dated 19/8/2023, if so permissible under law. Full stop. A copy of the said communication dated 19/8/23 is kept on record and marked as X. Right? Dismiss. Mr. Fugan, give him a copy of both.
I don't have my copy.
এটা copy করে কিনে দুটা copy করে দিয়ে দিবেন। You take it from him. তাছাড়া তুমি pilot trade দিলে। এটা pilot trade। খালি example দিলে হবে। Yes, most of it. You'll get a copy if law permits. Challenge.
Highly obliged.
Ma.
Timing item 3.
Sorry, I'm going back to the old matters, giving it slight importance. We'll finish it.
Lordship, I pray for a comment because Lordship, just now I have received a brief for earlier council, Lordship.
No, there is none on the on part of the petitioners.
Lordship.
Wait for some time. If something is there,
Lordship, otherwise, Lordship, when I don't know A to Z of this file, Lordship, I don't.
we'll have it on a different date.
Any other day, Lordship, may fix
Okay,
it.
fine.
Even in respect to item
We'll have it on 5th.
in respect to item number 5 also, Lordship, just now I have received 2 files from the department, Lordship.
Okay, okay. These are those, I think, absence.
Absence.
See the certificate,
Lordship,
TB certificate. If that is true, he gets 18 months leave. Then that action may be wrong, but you will have to satisfy me
I
on
will go through it.
Yes,
In item number 3, Lordship,
in item number 3.
Lordship, I will go through it. And
On the
five
prayer of
also,
Mr. Huh?
I've also, Lordship, have put some query.
3 and 5. On the prayer of Mr. A. Gugoi, learned CGC, list those matters again on 6/2/2024.
Lordship, Lordship, instead of 6, it can be 8, Lordship. 8,
Thursday,
8, 8,
8,
Thursday.
8 to
8, Lordship. Obliged, Lordship.
Timing item 5.
5 was same order. 6.
6 done. Item 9.
6 weeks on a month. Yes. You have read it?
My lord,
After this, what is that?
my lord,
Your ranks are foreclosed.
my lord. In the earlier repetition, my lord, wrongly, my lord, we could not annex the certificate. of
Whatever it
Aurora,
is,
my lord.
constructive res judicata comes in. Can't help it.
My lord, that can be, but my lord, in the repetition, my lord, we have a submission, my lord. Another, one thing is that, my lord, the certificate of 2009 could not be annexed. That was the wrong of the
Be
petitioner.
that as it may, but your stand basing on that was on record. This court considered that.
Actually,
Your
earlier-
stand, your projection, maybe the certificate was not there, but your projection on that was there. That issue was considered. And there is a
That-
finding, Mr. Counsel, there is a finding of a fact-finding authority.
My lord, that,
You have not challenged it.
my lord, we have stated in paragraph 11 that, my lord, that order, my lord, issued by the authority, my lord, could not be annexed and that was not challenged. That was the wrong of the petitioner.
Fine, that is just a passing remark here.
My lord.
But the court in the 3rd paragraph had gone to the meat of the matter and finished your case.
My lord.
Dismissed.
Obliged, lords.
Sorry, can't help it.
Number, huh?
I can't go beyond coordinate bench orders. Okay?
My lord. Deeply obliged, lords.
Item 10.
Yes, madam.
Lordship, this application is against a removal order.
What happened to the criminal case?
That is still pending, Lordship. No.
No finality.
No.
Yes, you tell me what is there, what procedural error is there?
Lordship, the punishment which has been imposed, that is maximum major punishment.
What will you do if you give your gun to somebody and he uses it for murder?
That was a case of Lordship in my.
When did you join your services, madam?
Years, have joined my service in the year 1998, Lordship.
And when is the incident?
And the incident, 2000.
11.
Yes, Lordship.
Then?
12, Lordship. And
Then Oh.
I was appointed as constable, Lordship.
13 years. That arms, you know the value of that arms.
Lordship, it was, I have detailed in my show cause reply that how the.
Madam, I'm telling you, try to cover up these points. The main thing against you is you went from there to Dibrugarh. You deposited these arms. You remain quiet. You did not say anything. Only when the matter figured and police came searching for you, you developed all these stories. Now you proceed with the matter. Try to dispel this
That's-
tentative conclusion.
Lordship, in the fact is that, Lordship, he himself surrendered. He himself revealed the fact.
Show me. Start from the show cause, page 15. Yes, madam.
Yes, Lordship. First show cause is, you are hereby directed to explain.
No. Don't read. Don't read. I've read it.
Uh,
What do you have to say on this? Anything?
Is my reply, page 21, Lordship, may kindly listen. Page 21. For the first,
Madam, you come to 1, 2, 3, 4, 5, 6 lines from bottom, page 15. You read from there.
during the time of your absence.
No. In the meantime, 6 lines from bottom, page 15. 1, 2, 3, 4, 5, 6. Right hand side. In the
When you
meantime.
arrived at the resort with food and you also assisted them, Amar Vina Visaragar Nagayos, to clean the room by removing the blood stains from the floor and dead body removed to the Bolroker, wrapping with the bed sheet, and you left the resort keeping the dead body inside the car towards
Burapahar.
Burapahar. That is
Come to the page 16, second paragraph.
Yes, on arrival of Dibrugarh, you deposited the arms and evening at the district maximum of police reserve and kept silent. On 17/9/2011, you were arrested in connection with Sonapur PS case number so-and-so and added section so-and-so. During investigation, it revealed that you physically got involved and assisted in the process of murder of Sonal Banerjee. Instead of obeying the duties prescribed by law, standing order and guidelines of PS.
Okay.
PSO, you handed over your allotted arms and public.
There is a
groups
list of
to
witnesses, list of documents, statement of allegations, everything is on record. Now, what is your reply?
My-
Page 21.
I stand by my show cause reply that I have submitted.
Yes,
there.
please place that, ma'am.
Yes, Lordship, page 21, Lordship,
Hmm.
here first. Let's start by second, starts from second paragraph. Let's start by show cause notice referred to here and I have been, third, that's third paragraph, sir. It is true, as stated in the aforesaid show cause notice that I was detailed PSO duty of Sri Kupul Gogoi and allotted the arms and ammunition as stated. I went to Guwahati accompanying Sri Kupul Gogoi as per my allotted duty. On 13/9/2011, I accompanied Kupul Gogoi, who was also accompanied by Vansi Amar Bhuiya and a few other people, including Vishal Agarwal, one of the friends, and one Sonal Banerjee to drugs resort at Sonapur. As ordered, food was
Fine, ma'am.
not placed at the resort could not serve the same, and as such, Kupul Gogoi Amar Bhuiya asked me to bring food for all of them. They were threatening me.
I got it. I've read it.
Yes.
You did not trouble yourself, madam. Only tell me
Follow.
whether that plea that now you are saying, that the plea that you have taken, that you had surrendered before police with all this thing, you have taken here. Have you? Now read page 16 again. Second paragraph. On arrival at Dibrugarh, you deposited the arms and ammunition and kept silent. On 17/9/2011, you were arrested. This is a reply which you gave on 12/3/2012, nearly 6, 7, 8 months afterwards. You have not taken that plea. That it is you who disclosed all those things. Right? So this is an afterthought. Now come to the your reply to the inquiry report.
Second.
That plea of yours is here. Page 25. Come to para 5.
Thereafter, they threatened me, my life and lives, of my family members, Lordship. Lordship, he is a man who is having
Read that.
para 5, page 25. Lordship.
Ah,
Yes. That thereafter they threatened me of my life and lives of my family members, and I was made to sit in the Bolero vehicle, which they drove till Katkati, where eventually Kukulgoy handed over my firearms, and I was under extreme mental trauma due to untoward incident, and I was absolutely at a fix and did not know what to do. However, after some time my nerves got pacified, and I drove to Dibrugarh Police Reserve and narrated the entire story to the Superintendent of Police.
now why this is not believable? Because this is not your stand in the reply, first reply. This is a development. If you had gone there on 7/6, you had gone, this incident is of 13.
13
Right, ma'am?
2011.
If you had surrendered, you would have been behind bars on 13, not on 17. Unfortunately, these things came to my notice. Right? Now see the penalty order, page 26.
After all, vision of livelihood loss, it's a because the
A person
situation-
involved in such a crime, maybe in the criminal case, he may be exonerated, no problem.
Not-
But this man cannot be,
Here it was an accident, and I was allotted duty with such a person who is having criminal antecedents, and the entire situation was under, it is not.
I understand, ma'am.
Lordship,
Understand.
willful negligence
I
on my
understand.
part, Lordship.
understand.
It is not, yes, of course, I was negligent to some extent, but it is not willful or deliberate. For that, this major punishment like removal from service, that is Lordship, that we are.
I am not,
like, for-
I am not, madam, with the incident. Incident can be taken care of. I am with your conduct. And the Superintendent Police was also basically with your conduct. Conduct in not informing this action immediately. It would have been a different situation altogether if you had gone up and said, this is the incident that has happened. They have done this. It would have been a minor penalty for you. You waited, you were arrested. When that criminal investigation in Sunapur case got up, you were arrested in Dibrugarh. And thereafter, these are the stands, 2 stands taken by you. The second stand is not there in the first. Anything else, ma'am? Anything else?
That is all, my lord, this punishment may be
We will consider.
Lordship, that may be,
We will consider, ma'am.
it's after all question of livelihood, Lordship.
If I can find out something, we will consider. Don't worry. Anything more? Yes, Mr. Bora.
Your Lordship, first and foremost, he is a member of a disciplined force.
Hmm.
And being a member of a disciplined force, he has to maintain certain kind of discipline in the organization. First and foremost, your lordship, if he had been involved, if suppose he is a witness, may not say, suppose we assume for the time being that he was just a mere witness to the happenings. He could have informed the nearest police station. He did not do so. He went till Dibrugarh. After he deposited the arms, then only after.
No, he has then also not said.
Then also.
4 days afterwards, he was arrested.
Afterwards, your lordship. After he was arrested, then.
You are additional government advocate or junior government advocate?
Junior government advocate.
Yes, what more?
So basically, it is proportionate. The punishment meted out to the petitioner is proportionate. It's not disproportionate. That is the humble submission. Because that is the only ground taken in the writ petition.
Madam, soon we will consider.
Yes, Lordship, only not proportionate, that is my lordship, that aspect may be considered, Lordship. Obliged, Divya.
Obliged, your lordship.
Dispose of.
Timing 11.
Level lordship, old pencil matter just now I have said, lordship fixed on 8 lordship,
Which one?
11 lordship. On 8 lordship.
I've informed. Mr. Goswami might have prepared well.
8 lordship, otherwise lordship
8.
8 on 8. Same day there earlier 2 matters. lordship.
Yes, Mr. Sharma, you are appearing for?
The private response number 7, my lord. Actually, so far as I am concerned, the matter has become infructuous. I have been appointed against some other vacancies.
I know that. Be here to assist the court. Or will it be any inconvenience to you?
Definitely no, I'll be there, my lord.
Mr. Goswami,
Lordship, I
13 matter, it has come up after some line. Let him.
Lordship, I pay for construction of the file. lordship.
You do whatever
On
you.
the second file.
11, there is another CPF matter. 15, who is appearing in that?
15 lordship.
Ah. Mr. D. Thakur. D. Borkotoki.
15 lordship.
Dismiss, nahi? Or not pressed? Okay, okay, fine. Okay, fine. This is the one. Who is it? 16 to Itubeli.
Lordship, I will reconstruct it. One
Okay.
second.
On the prayer of Mr. K. Gogoi, I heard Mr. S. Goswami, S.K. Goswami, learned counsel for the petitioner. Also heard Mr. K. Gogoi, learned counsel, CGC for the state respondents, and also Mr. P. Sharma for the respondent number, learned counsel for the respondent number 7. So Mr. K. Gogoi submits that he be granted a week's time to have his records, to have the records of the petition reconstructed. He have his file reconstructed. Full stop. Prayer accepted. Is this matter again on 13/2/2024? Okay. We'll have that on the 8th. I have fixed too many matters. It may again take time.
There are 3 petitioners. One has already been appointed up in subsequent selection.
Subsequent selection. So this only thing, one thing, Mr. Goswami, what I found in this affidavits filed by this Debolina Thakur, really, after a long time, a good affidavit I have seen. Detailed, maybe it may not be correct, but the manner in which it is structured makes it good reading.
Details affidavit will be given. Details.
It has to be appreciated.
Obliged, lordship.
Obliged.
Timing 16.
My lord, may this matter may be taken up the first week of the February, lordship.
Today, otherwise it will be dismissed.
Lordship, that then
You file 13 matters we are not carrying forward.
add to lordship then.
Whenever I'll call it once more, whenever it is called, if nobody appears, dismissed. 13 matters cannot be given such a long handle. If you have some bereavement, some problem that you cannot come to court, I am there.
Remand by the single bench, initially repeated.
I know that. I've seen it. Call Mr. Mujumdar or you argue. Yeah.
Timing item 64.
I said, Mr. Dina,
This matter, Mr. Dinat will be appearing, so he has asked me to pray before it to 4:30, 2:30.
Okay.
At two matters are fixed.
When Mr. Nat comes, ask him to inform and get hold of the petitioner also. Yep.
Daily list, order no step, item 27.
বাকি শেষ নেকি এটা হৈ গ'ল নেকি এটা হৈ গ'ল
The service was presumed to be my completed lordship. Justice service, my lord, because of wrong impression lordship, I could not take it. As such, service is complete lordship. As per number 5. And another way lordship, as per order, interim order of dishonorable court lordship. Everything has been discussed, my lord. There was observation, my lord. There was no bar to consider the petitioner's grievances, lordship. My lord, two language.
No. No, you will have to take the stick. There is an order, 17.5.
Justice service law.
Why have you not taken it? 17.523. We will delete that person.
Some more time.
Clear-cut order of this court. You can't say there is no order. There is an order.
More time, lordship.
No more time.
Justice as.
What is the issue?
Observation. Kindly see order, lordship. The interim order, lordship. That is the reasonable court already observed, lordship. That is order dated 23/9/2021. Two language teachers have been, my lord, provincial, but the social science teacher has not been provincial. I am social science teacher.
So if you don't take steps on service of the person whose appointment you are challenging, how can this matter proceed?
That is the problem, my lord. My lord, observation that.
We will delete it. Once I delete it, my next order would be the repetition. Nothing is there.
Then sometime.
Today.
My lord.
Today.
Justice service lordship.
Today. There is still time.
My lord, by Monday lordship. I'll communicate. My lord, it will have to be handed over lordship. Monday lordship. By this 3 days lordship. By Monday lordship.
List this matter again on 1/2/2024. Within which time, if the affidavit of service of notice upon respondent number 5 by way of Dasti mode is not brought on record, the writ petition shall be dismissed on the set count.
Lordship. All right.
You can't take it casually. You are enjoying something, you have to take the consequences of it. It was passed in your presence, in your prayer. Thereafter, you don't take. That's why I'm not very happy.
My lord, there was some observation.
Yeah, 5/2.
Lordship. All right.
But Mr. Khandakar, don't come and make a prayer for it. I'll dismiss the.
By Monday, I will take lordship.
I want the affidavit by 5th.
Lordship.
Item 28.
May I please the lordship. Lordship, service upon the response number 5, that is Nagaland Open University, my lord, could not be taken, my lord. I'm praying for strike of this name, my lord. Otherwise, my lord, the issue is that, my lord, I have obtained the MA degree from Nagaland Global Open University, my lord. That is said to be invalid by the Director of Secondary Education, my lord. UGC will decide, my lord. UGC has already appeared, and on the last occasion, they have got time to file the affidavit, my lord. Otherwise, my lord, division bench also decided this issue.
What is that issue of? Yes, Mr.
So I am appealing for the petition of respondent 6, lordship. They have in paragraph 2, they have stated that respondent 6 is a private person who is also working with the petitioner and staking her claim to be appointed as the in charge. But however, as per my instruction, the one Mazdur Ali was appointed as the in charge petitioner. So I have
Presently, my lord, one Manzoor Ali is holding the in charge, my lord. At
so
page,
respondent 6 is unnecessary part.
page 7.
No, Mr. Counsel, forget all this.
My lord.
Justify your claim with regard to this degree from Global Open University.
My lord. At the time of when I acquired the, my lord, this MA degree, my lord, that time this permission was, my lord, it is valid, my lord. The as per, my lord, page 72, my lord, kindly pay note.
Your case is that this is an in-campus degree, not an off-campus degree.
Yes, my lord.
Huh?
I have, my lord,
Gone there?
when gone there and
Okay.
seek for.
This is an MA
examination.
course? This is not a online
No.
distance education?
No, my lord. I have.
Show me the period wherein you had taken permission, leave and all those things.
My lord,
Then we will ask them.
my lord, at page 27, my lord, my pass certificate is there, my lord.
I'm not on the pass certificate. The issues leading to the pass certificate. So you were a student of that course?
Yes,
This is not PhD that you did not attend classes. You have to attend classes?
Yes, my lord, I have.
Nagaland,
Nagaland, my lord.
where
I
is
have
this school
done
situated?
School, at my lord,
Bezana,
Bezera, my lord.
here,
Yes, my lord.
from here, daily morning you go.
No, I have
Then?
done in from distance, my lord. For the examination, I went
Distance
there.
is not permissible.
My lord,
Show me where the DEC permission is there for that school or that university.
my lord,
Because if you come to your synopsis,
my lord.
read what have you written.
The petitioner before the.
Last line. Further, the respondent number failed to appreciate that fact that the petitioner had obtained the MA degree from Global Human University by enrolling and appearing in examination in the campus of the University of so-and-so and not from any off-campus study center. Justify this. That you had the permission. I'll not even go into the validity whether that university is proper. I'll not even go. Just satisfy me on this. Problem? We'll have it on a different day. But this is the. Let's this matter again on 6/2/2024
6 to my lord. For final disposal.
for further hearing.
I'm deeply obliged.
You satisfy me, then we will catch hold.
I'll oblige. But even the recently the division bench has dealt with this issue, my lord. EGC has filed an appeal, my lord. The single bench already said, my lord, this the period when I my lord, done my MA degree, that period at that time these degrees are distance learning education is valid. Thereafter, my lord, EGC has filed a writ appeal.
You bring that judgment on record.
Yes, my lord, I have
Please.
recent, my lord, on the 6th, my lord, I'm deeply obliged.
Yes. You have got the affidavit, Mr.
Yes,
Montauk?
I got that.
Yes. What is your submission now?
My submission that, my lord, there, your lordship kindly see that annex for the annexer to page 27, my lord. There is some guidelines, my lord, regarding, my lord,
Just
selection.
recapitulate the arguments you had made last time. Your case is that this man was considered in some school, other school.
No. That this man was considered not fit to, not
That's what
fit,
I'm
my
saying.
lord, for particular school. How he can fit to 26?
That's what I'm saying. There is a finding
Finding of
by
my
the
lord,
authority
authority.
that this man is not fit because he does not fulfill the criteria in that
and-
guidelines.
My lord.
And
And-
then you question that once the government has, it's a government order.
Come here. That
Government
is what
has,
challenge.
government has not challenged, attained finality. Government has said that. How can you, with that order standing, now hold that he is eligible? Because his eligibility was questioned in that order. Who is appearing for the private
And also,
respondent
my
6?
lord, there is a
Yeah.
fine. There is a criminal case pending against him.
I'll not even go into-
Seated. So that is not been denied.
No, no, I'll not even go into that. You get over that order of the government. This is no public employment.
My lord,
Huh?
my lord,
This is just a presidentship.
my lord.
You get over that.
Page 75.
Have you challenged that?
No, my lord.
Then
No, because my lord, that order, my lord, only government, that order, earlier order cancelled, my lord. That point of time, I was in work.
be that as it may, the material there is, and that order was passed
My
at your instance when the matter was remanded by this court.
By this court.
my lord,
My Lord Justice Goswami's order.
My lord.
my lord.
Then
No, that part, my lord, that is only question, my lord, that point of time, my lord, I was working as a teacher, my lord, in a provincial school, my lord. Subsequently, the school was provincialized, my lord, my part gone, my lord. I left this job, my lord, in 2013, my lord.
No, that is not. the
that
correct-
is not the issue there, Mr. Where is that order of the government? Wait.
And that is on the page 75, my lord. And your lordship kindly straightway goes to page 75 and 76, my lord. Start from 75.
Type copy. Yes.
In paras, page 76, the Rakimuddin Ahmed is a.
1, 2, 3, 4th paragraph.
Yes, he is a political worker. So, my lord, a very first line of the guidelines, he must not be any political background. But there is a finding that he is a political or active politician of the, my lord, AIDF and BJP. So that finding is there. Without going to others, my lord. Because your lordship kindly see the guidelines issued by the government, that is page 27, my lord. Very first is that one local educated reputed citizen having no political
Mr.
career.
Soikia, come to page 76.
76, my lord.
Forget all that is there.
My lord.
Forget everything.
My
Just come to the last para.
lord.
Read that.
On careful.
After careful consideration of all aspects and on perusal of the all facts and findings as they stated above, that the Rukunuddin Ahmed had been given adequate opportunity of hearing. It is observed that the Rukunuddin Ahmed does not fulfill the criteria and stipulation laid down in the guidelines dated 24 June 2024
Same guideline.
and later dated 7 December 2026 issued by the government to constitute the SMDC.
Hmm.
Hence, the claim of the Rukunuddin Ahmed for the post of president of SMDC cannot be considered.
Now,
My lord.
now, is there any other guideline holding the field? Or is the same guideline?
Same guideline.
Guideline is.
It is wrong.
Guideline is.
I am with you. It is absolutely perverse.
My lord,
But this is an order passed after hearing.
my lord,
Pursuant to orders passed by this court.
my lord,
No challenge. This has attained final.
my lord.
Given you a seal. Not
My lord.
eligible to be. If it was promotion to a service, we would have interfered. This is appointment. Honorary.
My lord,
No right of yours is violated if you don't get this.
my lord, otherwise. my lord,
Other than if you have some other intention, I don't know. Otherwise,
My lord,
it's social service. I said, leave it, do other some work. This is social service, Mr.
my lord,
Soikia.
absolutely, my lord, social.
Go,
My lord,
do
my
some
lord,
other
why,
work.
my lord, this order we had not challenged, my lord. Because my lord, that this order purportedly passed that time of I was working as in a unprovincial school, my lord, in the Bensar school, my lord. School was provincial
No.
of 2013.
No, Mr. Soikia, there are other grounds also.
My lord,
Politicals.
the political part, my lord, they.
When this is,
No,
you
but-
challenge it, I'll interfere.
No, my lord, therefore.
Mr. Soikia, you challenge it subject to law of limitation.
My lord,
Delay, latches, challenge it. We will interfere. But this is staring at me. I can't direct.
my lord, regarding the political debt issue, my lord, that AIDF and all, my lord, that point of time, I am
not
maybe a
concerned
worker-
with the party. I am only concerned with the word political.
And if my lord did come to the guidelines, my lord.
I
the
know that.
Political phase, my lord.
That has been also dealt with.
I'm not occupying any post, my lord.
I know that.
may
That
be
has also
politi-
been dealt with.
So, my lord, I may be a political ideology, my lord.
The
It is
beauty of
separate
this
issue, my lord.
order of the secretary is he has interpreted that word political to mean any activity.
So here,
Very good.
my lord, normally, my lord is go to the paragraph number 4, my lord. My senior friend pointed out, my lord. Then, my lord, it is said that I am supporting the AIDF and BJP, my lord. That's not so, my lord.
I'm not on that. I'm not on that.
And that situation, my lord, changed, my lord, because that was in 2016, my lord.
I'm not on the political party involved. I'm on the politics.
And regarding my lord, politics, my lord, I have to hold the post of the considered election, my lord, as per the guidelines. Now, Lord, may please to come to the guidelines. first.
You get this order interfered with and do whatever you want. But till this order is substanting Standing, we are not interfering. Yes, Mr. Monta, give me the facts.
My lord, your lordship kindly see, he was appointed as a my lord at page 37.
This is school college, what is it?
School is. Yeah, high school.
Ailatanki Osmania. Alitangia.
Ali Tangani Usmania Higher Secondary School. And he was, my lord, appointed as a chairperson, my lord, of the managing committee, that is by annexure.
What is your qualification, Mr.
My qualification is MA, my lord.
MA.
My lord.
MSc?
MSc, my lord, sorry. MSc.
Okay. Then, Mr. Monto, what happened?
Then he was appointed, my lord.
There was some selection, something?
Yes, my lord, name forwarded, two names were forwarded.
His name was also forwarded.
Forwarded, my lord, he was appointed.
Okay.
So I
When was that
also
for? Where is that document?
That document, my lord,
At page 32.
page 32, my lord. So his name is serial number 2. My name is serial number 1.
This is just a panel. Serial number is of no use.
No use, my lord. Yes, exactly.
I will held that.
So I am MA, BA, and he is MSc.
Okay, that also is of no
No,
consequence.
no, my lord, I am go by that findings only, my lord.
Hmm.
So then he was appointed by annexus 6, page 37, my lord.
Hmm.
But before that, you also kindly want to look into the guidelines, my lord. That is annexure 1, page 27. The same guideline that is in 14 June 2016. And that is the only guideline by the government of Assam. There is not provided by any act, my lord.
No, there is a change here. Now earlier it was by the government, now it is by the
This-
deputy
they
commissioner and
given
the guardian minister. Yes, what do you want to show?
Page number 31, my lord.
Hmm,
31, that,
hmm. And that is the amendment.
my lord.
Hmm.
Partial modification with the guidelines to ensure. That is 27 October 2021. Page 31, my lord. Then, my lord, I oppose this honorable court because in earlier cases, my lord, that your lordship already gone through that order, my lord. So he opposed, he was selected in another school, my lord. He was not been granted, he was not selected, and he opposed this honorable court, and this honorable court remanded back the matter, my lord.
And in support of your case, you rely on this order dated 3/3/2018.
My lord.
This is pertaining to the respondent number. So Soikia, your respondent number?
6, my lord.
6.
My lord.
R6 appointment as president of which school, Mr.
That is,
Dogaon AK High School, right?
yes, AK High School. Dogaon DAE, Dogaon AK High School.
Dogaon,
So now this is Ali Tangani. This is
different.
now this is Ali Tangani Osmania High School.
Different schools.
Different school.
Different school.
So he was not fit for that particular school, and now he's fit for this particular. So that is my case, my lord. And in fact, my lord, there's a search sheet against him, my lord, and I annexed that search sheet. And from the affidavit filed by him, my lord, there is no denial, my lord.
Okay, where is that charge sheet?
Search sheet, my lord, at page
Page 89,
89.
87.
87 is the translated copy, and the original one is, my lord, 89.
This charge sheet is of 31/7/2019,
19.
right? No. There is some other.
89 law number is not there, my lord.
Zahar, charge sheet is Mr.
Yes,
87.
my lord, 89.
87.
Yes, 87, my lord.
This is of 31/7/2019. And his selection here is which date?
Selection, that is, my lord, forwarded the names, my lord, that is 2011, 21.
Impugn order is dated 8/9/2022.
Where is that?
Page 37 is the impugn order, madam.
37.
37.
Okay, let's just have that guidelines once.
Guideline page 27, madam.
So your submission would be that para 3, clause 3.
Clause 3 and my lord, page 28, very fast. Serial number 1. One local educated and reputed citizen having no political career.
Mr. Soikia,
My lord,
that's all, Mr.
My lord,
Soikia.
my lord,
Even if we ignore that earlier finding of yours,
my lord.
there was a charge sheet against you.
No, my lord. That's my lord, page number 89, my lord. Name is not there, my lord.
Your name is not there.
Not there, my lord. Page number, my lord, me to page number 89, my lord.
Runu didn't.
Yep.
Yes, Mr. Monto, what is
No,
he
no,
saying?
no, that's, your lordship kindly see, my lord. I made a statement.
Mr. Mustafa Nasia, number 1, Mohammed Rupal. Number 2, Mr. Abdur Rahim.
Yes,
Yes, my lord, the Rupam Tisar, that Rupam, that lordship kindly see.
originally it's at page 90, 89.
89.
Ah,
89, my lord.
his name is not there.
No, that Rupam Tisar is the same man, my lord, I made a statement.
Rupam?
Page 21, my lord.
Where?
Your lordship can, page 21, para 17.
No. Show me the document first.
My lord. Page 89, my lord. Muhammad Rupam, within bracket Tisar, son of late Riyazuddin. So that
Where? Absconder.
absconder, my lord.
Mohammed Rupan.
Muhammad.
Oh, son of late Riyazuddin.
And that I
Yes,
just
show
made
me
a-
your affidavit. Mister, show me, have you filed an affidavit?
Yes, my lord.
My lord.
Yes, you have filed an affidavit. Riyazuddin. Oh, that's enough.
The name of the respondent was wrongly recorded the Rupam Tisar in the said FIR and charge sheet.
Yes, Mister.
So that is not been denied. Page 17.
Mr. Soikia,
My lord. My lord,
you are
someone,
absconder.
my lord, someone filed a specific allegation against a
And
teacher,
I'm
my lord.
just
My lord. My lord.
thinking. You are there.
No,
Your name is there.
no, my lord.
You deny that.
I am denying, my lord, because my lord, someone's specific allegation against a school teacher, not a road, my lord, person who is going to the road, my lord. That is specific, my lord, allegation.
So you say that you are not, have you been arrested in this
No,
case sometime? Huh?
No, my lord.
No.
No.
Oh, because you are an absconder.
Yes, my lord. Yes, shown as an absconder. No, there is no specific denial, my lord. In para 17, your lordship can in page.
Mr. Monto,
Hello.
we'll not go into
My lord.
disputed facts.
My lord,
If he says we will not put a slur on him
my lord,
by saying that he is an accused here, why should we do that?
my lord.
We'll
But-
only have
but- but
that
But there
page.
is no specific denial that there is no charge sheet against me, there is no criminal case pending against me.
Forget
There
it.
is no such-
Forget it.
They denied that charge sheet, not.
That
charge sheet
may
not-
be a drafting error.
Maybe, my lord.
But if that is not very clear, why should we
My
pull him in? Because my order would have the effect of police being behind him if he is not there.
Sorry, my lord, I don't like to put him in that.
That will not put him into that. So criminal case you are out. We'll not go into that.
My lord.
And the other point, do whatever you want. If you want to challenge it, subject to latches.
No, regarding my lord, subsequently, as per that order, my lord, my presidency has been cancelled by this authority, my lord. Subsequently, my lord, another school, my lord, I have been appointed as my lord, vice president, my lord. Therefore, I am not challenging it because
That
my lord,
is-
that
that
situation,
is-
my lord, whatever
that
is
is-
there, my lord, situation.
That
He
is
vice
the,
president,
that
he
is the right
No, 5 minutes.
of the government or the authorities. We don't have that right. We can only act within the parameters.
My lord, absolutely, my lord,
Okay?
my lord.
So we are not even going to direct Mr. Mohanto's appointment because there is no approval.
My lord.
We will say, we'll leave the matter to the government. Let the government take a call. whatever it is. So Monto, we can't pass an order
My lord,
directing that you will be the president.
my lord.
Because that procedure in your case is also not followed.
Then, my lord,
I'll remand back the matter.
yes, remand back the matter, they will consider record, yes.
And then maybe there would be a situation wherein there has to be a fresh proposal.
My lord. Because suppose after appointment that earlier recommendation has gone.
Gone.
Otherwise, my lord, in this case, my lord, another person is challenging my appointment, my lord. Then petitioner name they obtained by fraudly, my lord. Then petitioner, my lord, come to the High Court registry, my lord. They filed an petition against them, my lord.
What? I didn't get it.
Another case, my lord, filing by the other petitioner, my lord, challenging my appointment, my lord. Like
This appointment, this school.
This appointment, my lord.
Then
My lord, that petitioner whose name added as a petitioner, my lord, they come to the registry of this honorable court, my lord. By saying that we are not the petitioner, we have not filed any application, my lord. This is the conspiracy of some other person, my lord.
No,
That
that
petition has been
is-
filed before the registry, my lord.
that-
And even my lord, you go to the my affidavit, my lord may when verify the appraise the attitude of the respondent, my lord. He was earlier appointed as an assistant teacher, my lord. And his appointment also set aside by this honorable court, my lord. And he is known as the king of the fake certificate, my lord. He is involving the issue of B.Ed certificate, my lord.
So that is why he may know so many things. That's what your allegation.
My lord.
Okay, dispose of.
My lord.
What is this IA? So,
I-
madam, there is no requirement for your IA.
No, already, my lord, school authority make no confidence motion against him also, my lord. Because he is, my lord, utilizing the fund.
No, I was only, when she
No,
filed that
despite
IA, I
of
was
stay
only,
order,
I'm
he-
not on that. They say that because of this dispute, the SMDC is not functioning. And accordingly, the midday meal scheme and all. Now it is okay.
No, there is no.
After my
midday meal.
last order,
High school, no.
I think I
midday meal.
passed on, I did not pass on, will pass on.
In
High
that
school,
respect, my
no
lord,
midday meal.
already commissioner had issued a letter to the principal to file an I in this case, my lord, for vacating of the stay order. But principal is not filing any application, my lord.
Will.
My lord.
May I say, my lord, if my lord is for the direction of remand, my lord.
Madam, if I remand the matter, I will require the
My lord,
authority of the district,
my lord,
DEO, whoever it is,
my lord,
to take over the management
lord.
of the school and run it.
my lord. And a time frame, my lord, maybe.
No time frame.
My
The
lord.
DEO will run it till he wants it, till the whole matter is resolved in terms of the guidelines.
My lord.
DEO will run it. Enough?
Yes, yeah.
Diplo.
Highly obliged.
My lord, financial affairs,
Due,
DEO, everything will be by the
Already
DEO.
there is a
He will
stay
be
order,
the president of that.
Already there is a
If
stay
my
order.
lord, they simply remand it.
No, I'll not. I'll not.
Because-
I'll not.
No,
I
already-
will direct the DEO, even I can direct the director. She'll be the president there. He or she will be the president there. I've been seeing this very sorry state of affairs of this school manager.
School management.
my lord.
So we'll have to be a bit. Thereafter, as per guidelines, you proceed.
Probably some matter you will.
My lord, till the
That is in
decision
respect
taken
of
by
my
the
lord.
director, then my lord, that position may not be disturbed, my lord, because my lord, let director maybe take a decision, my lord. Till then, financial power, my lord,
No,
I have no
financial
objection.
power.
You want the financial power.
Already there is a
You
stay
want the
order.
financial power.
There is a stay
Financial
order.
power, my lord, DO can take it, my lord, we have no objection on that, my lord.
Then?
But my lord, my entitlement as the president, my lord, till the
No.
decision of this honorable director, my lord, then my lord.
No. We are interfering.
Otherwise,
And
my lord,
then
my lord,
saying fresh proposal. And in the integnum, DEO.
Diplo.
Mother day.
Look, he's coming, just we can apprise the
Okay.
court lordship.
The thing here is, the petitioner is not entitled. I'm not saying she is entitled. But your office, once having passed an order that the person whom she pointed out, that this lady is not entitled, you have directed that her recovery should be made. After a few days or month, you have paid her 14 lakhs rupees. What would a citizen feel? Here, all legal pleas are taken, but what are you doing there? That's the only thing I wanted. So please take corrective measures, whatever is to be done. Inform him, get back to us. But if even one person is in benefit, getting the benefits, we'll direct that benefit to be given to her also. You go wherever you want.
Here,
Because Mr. Your name, please?
lordship, just I
Mr.
pointed
Kaur,
out-
I'm sorry. This order, maybe you were not there at that point of time. Page 45.
Lordship, I already here.
Here, it's a specific order that that person who is been illegally given should be recovered. But what is noticeable here is this order was passed in February. And in March, say 1 month, she has been allotted 14 lakhs.
No, sir.
Now, Mr. Kumar, forget the legality. What would a citizen think?
On 27 March.
27 months. So, Mr. Kumar, you're not keeping well. I'll not delay it. I'm giving you 15 days time.
Lordship.
Please do the needful.
Lordship, one thing is there, Lordship. The file under which the benefit was given, Lordship, it is not traceable in our office.
That
nothing is there.
you
So-
have.
So Lordship, Lordship may give at least 1 month time, Lordship. In the meantime, we will do the needful. We construct it, Lordship. Even FIRs also lost in the, as per Lordship's observation, Lordship. We have tried to trace out it, Lordship.
Okay.
We have,
In terms of the order dated,
even Lordship, one FIR.
11/1/2024, Mr. Nayan Kaur, Secretary, Department of School Education, is personally present before the school. Mr. Kaur undertakes that the remedial measures as may be required in the matter shall be taken and the outcome thereof shall be placed before this court on the next date fixed. On the prayer made by Mr. K. Gugoi, lists this matter again on four, 3/2024.
Lordship.
I'm giving you enough time. Mr. Kumar, this is public money. But you have to do something. I'm sorry, because I was not getting the information. That's why I required you here.
And Lordship,
You can immediately leave and get yourself written.
Lordship, even Lordship, last,
The personal appearance of Mr. Kumar is dispensed with.
even last 3 days, he is on leave also, Lordship.
Please, I'm sorry. You should have informed me, but this court is not that
Lordship.
inhuman that it will not understand. We could have accommodated you on a different date.
That's
Okay,
because
there
that
are
is-
other
that's
file
because there is a specific order, Lordship. That's why, Lordship,
No, no, no,
critical on our part also.
no
Lordship.
problem.
On our part also.
If any such problem comes up, officer is not keeping well,
Lordship.
genuinely,
Even also
please,
today
please
morning,
place it out before us.
today morning,
We have nothing, this case. We can have it in a day or two there later.
even also today morning, we have thought for video conference, but officer says that he will try to come here. That's why, Lordship.
I'm grateful for that. Thank you,
Yes.
Mr. Kumar.
And Lordship, other matters also. 60. Other matters also, Lordship.
Item number 60.
I have apprised him, Lordship, and Lordship may give sometime, Lordship, he will. Lordship. Item 16, Lordship.
16.
No, not 60,
No, 16, Lordship.
not 60, not 60. What was that?
On
21.
Item 21.
Yes, 21.
21, Lordship. 21, Lordship.
21.
Just now, Lordship, I have give him the knowledge about that particular order.
Ah.
So Lordship may give some reasonable time and he will work out.
Mr. You are also looking after the higher education department.
Lordship.
He will give you the file.
Lordship.
Please go through it. There was a direction, it went up to the Supreme Court. Then the de novo inquiry was done. And finally, an order is passed on 7/10/23 by the director. De novo means everything anew, new. Earlier things gone. Now there was an inquiry. We will not even hear him on that. But after that inquiry, you have to pass an order of penalty. What your director was done is, she has revalidated or he has revalidated the earlier order, which is not permissible. 1. 2, in the division order itself, division bench order itself, you will find that this person had retired even prior to that. So how can an order of dismissal be now passed against him? 75-year-old man. This case will give you 10 days time. Please do what is required and
Lordship.
communicate.
Lordship.
Today, Mr. Kumar, Secretary to the Government of Assam, Department of School Education is present, and he has undertaken that he would review the matter and the outcome thereof shall be placed before this court on the next date fixed. Lists this matter on 12/1/2024, on which date Mr. Gugoi shall place on record the outcome of the review undertaken
Lordship, when-
undertaken to be taken by
which
by Mr. Kwon.
date is Lordship?
This is 12 to
Lordship, instead of 12, then 19 Lordship. Then
19.
19.
Okay, 19.
19 Lordship.
So 19 may be difficult.
Lordship.
We'll have it on 16th.
16 Lordship, Lordship,
16.
Lordship, Lordship.
Or if you want, we can have it a day before also, no problem.
But 16 Lordship will do, 16 Lordship.
Or,
They will
at
also
12th week, 12, 13, 15,
Lordship,
16,
Lordship is 16. They will,
16.
they will
Okay.
get some time, Lordship.
On latest on 16.
Lordship, Lordship.
Thank you, Mr. Kwon.
Apologies.
Item 60.
Yes, what is the instruction, Mr. Gogoi? Yes,
Lordship, Council B. Gogoi is on legs today. Lordship, there's a parthead matter going on in court number 12. Lordship, that will take some time.
you get the instructions, place it here because the matter is, here also it's waiting. You get the instructions, whatever it is.
Actually, I was being told that it was an NMC directive. NMC will have to bring some new instructions.
Where is NMC? I'll go to the NMC council then.
Uh,
We'll take this court to where the NMC council is.
Lordship, if possible, can it be taken up on Wednesday?
No, today.
Gogo has come. Lordship, I have also not received any instruction. I have mailed 2 times, Lordship. So Lordship may accommodate for today, Lordship.
We have been accommodating this matter from when? From 15/12, we have been
15 Lordship,
accommodating this matter.
Last day I am appeared on behalf of the National Medical.
I only want what is your stand? Thereafter, we'll pass orders.
National Medical Commissions, last week I am appeared, Lordship. So accordingly, I have mailed to them, Lordship. So Lordship, may next week I will again try, Lordship.
We'll not give you a long date.
Lordship.
Because if this boy is eligible, let him complete his course.
Lordship.
Otherwise,
Lordship.
and see one thing. For this person, the state has spent enough.
Lordship.
So if one examination he can clear, that money
Lordship.
can also be accounted for.
Lordship.
Because to make a doctor, it's not that the state is not spending, it's spending heavy amount.
Only just I sought one clarification from a National Medical Council Commission, Lordship. Whether if there is no time limit, Lordship, then which law will be people and what procedure will be they have taken, Lordship.
You,
Whether it should be
as a measure,
Lordship.
one-time measure,
Lordship.
give him. Let him finish this course. You only want one examination, Mr. Das?
Lordship, I have to clear seven semester and the final nine. 7 and 9.
7 and 9. Do it. Within a period, if he doesn't do, he'll
Our
go.
rule is very limited, Lordship. Just National Medical Council will clarify, Lordship, whether it will be done or not. Lordship.
In spite of the directions passed earlier, even today, no instructions have been placed in the matter by the respondents. However, for the ends of justice, as a last chance, the respondents are given further a week's time to bring on record their respective stands in the matter. Failing which, this court would proceed to pass appropriate orders basing on the materials available on.
Lordship.
List this case again on 8/2/2024.
Lordship.
2 more candidates, Lordship. In their case, Lordship, they have not received any notice. They have also crossed 10 years, Lordship.
You bring that on.
I have given the example, Lordship.
Oh.
Talukdar Hussain.
Okay. We'll do something, don't worry.
Lordship.
Okay, Cyril, good. All right, better.
Daily list for admission, item 31.
Milord, I have gone through the documents carefully, Milord. Milord, that Tulsiram Patel is squarely applicable in this case, Milord.
Okay, fine.
Milord, and Milord, on the last occasion, Milord.
I wanted the contemporaneous records. Have you got the records with you?
Milord.
Just mark it. No, no, no. Yep. You have a copy?
Milord.
Paragraph?
Paragraph, Milord. Paragraph 61 regarding that exclusion clause, Milord. Milord, departmental proceedings totally excluded, Milord. applying this Article 311 to second. Paragraph 61. And paragraph 136 is regarding no anterior or preliminary inquiry required, whether the DP should be dispensed with or not. And paragraph 130.
No, wait. 61 para, then next.
Next, para 130.
Okay.
It should be not reasonably practicable that Oxford Dictionary has been referred, but it should not be not impracticable. Paragraph 130, paragraph 61, then paragraph 136, no second or anterior or preliminary inquiry required, no backdoor policy similar regarding holding of inquiry, whether the inquiry should be dispensed with or not. Then 125 and 126 on the other day, your lordship has already, my lord, seen that paragraph, my lord, regarding non-mentioning of Article 311. And regarding paragraph 102, I think, my lord, the only way out is the departmental appeal. Paragraph 102, the appellate provision.
Okay. This is your records.
He has been given 4 opportunities. He was absent for near about 2 years. 1 newspaper advertisement.
So this is the only document, Mr.
My lord, and that newspaper advertisement and other notices, my lord, has been incorporated in the affidavit.
Can you give me a Xerox of this?
My lord.
Only this page. Only this page you are relying?
My lord, the annexer, my lord, annexer 15, my lord.
Of the repetition?
No, my lord, of the Executive Council resolution, my lord.
This page?
And subsequently, my lord.
Subsequently, mark.
Annexer 15, my lord.
Annexer 19, 15. What is this? This is the note which was placed before the EC.
My lord. So, my lord, the termination order.
What is the date of this EC meeting, Mr.
12 March 2020. And the termination order was 24th September 2020.
Okay. And you say the note to EC annexure 15. Okay. Only these 2 are there, Mr.
My lord.
Anything more?
My lord, may I read that second proviso of 311 to my lord?
You can read. You can read. Constitution can't depose. Constitution.
Constitution.
Constitution. Yes, Mr.
311.
Yes.
To B, proviso B. Prior to that, my lord, before A, my lord, provided further that this clause shall not apply regarding, my lord, departmental proceeding. Where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied. It is important, my lord, is satisfied that for some reason, comma, to be recorded by that authority in writing, comma, it is not reasonably practicable to hold such inquiry. So there should be some reasons, my lord.
That's all. That's all I want.
Recorded. And
Mr. Fukan, I don't want anything beyond proviso to proviso B.
My lord.
I don't want anything beyond proviso B.
My lord.
Proviso B, you are in support of this contention of yours.
That
you have
Tulsiram-
relied on Tulsiram Patel and this note.
My lord.
Tulsiram Patel has not said proviso B to be bad.
My lord, may I read again, my lord, paragraph 126?
No. Has Tulsiram Patel in any form said you have to not follow 131 proviso to be?
No, my lord, it has been stated in the Tulsiram Patel paragraph
That-
126 that Article 311 to second proviso should not be recorded, my lord.
Okay.
If, my lord, the Article 311 to second proviso not recorded,
Hmm.
then the termination order won't be invalid, my lord.
Invalid. Okay.
Paragraph 126, my lord. And prior to that, my lord, paragraph 61, my lord.
No, we'll have 126. We have read it down that day.
When DP excluded, it is excluded completely, my lord. No preliminary inquiry, no anterior inquiry, nothing, my lord. Only way out is the departmental appeal, my lord. Paragraph 102. Kindly turn to paragraph 61
So, Mr.
and
Mr.
paragraph 138.
Just to understand your contention with regard to paragraph 126,
Several paragraphs, my lord. May I
138.
138,
Okay. Yeah, please.
the last.
Hmm.
Page 507, the last 5-6 lines, my lord. In considering the
You read the
relevance,
whole paragraph.
my lord,
Read the whole paragraph. Where a government servant.
where a government servant is dismissed, removed, or reduced in rank by applying clause B or an analogous provision of the service rules,
Hmm.
and he approaches either the High Court under Article 226 or this court under Article 32,
Hmm.
the court will interfere on grounds well established in law for the exercise of power of judicial review in matters where administrative discretion is exercised. It will consider whether clause B or an analogous provision in the service rules was properly applied or not. The finality given by clause 3 of Article 311 to the disciplinary authority's decision that it was not reasonably practicable to hold the inquiry is not binding upon the court. The court will also examine the change of charge of malafide, if any, made in the writ petition. In examining the relevancy of the reasons, the court will consider the situation which, according to the disciplinary authority, made it come to the conclusion that it was not reasonably practicable to hold the inquiry. If the court finds that the reasons are irrelevant, then the recording of its satisfaction by the disciplinary authority would be an abuse of power conferred upon it by clause B and would take the case out of the purview of that clause, and the impugn order of penalty would stand invalidated. In considering the relevancy of the reasons, my lord, it is important. In considering the relevancy of the reasons given by the disciplinary authority, the court will not, however, sit in judgment over them like a court of first appeal. In order to decide whether the reasons are germane to clause B, the court must put itself in the place of a disciplinary authority and consider what is in the then prevailing situation a reasonable man acting in a reasonable way would have done. The matter will have to be judged in the light of the then prevailing situation and not as if the disciplinary authority was deciding the question whether the inquiry should be dispensed with or not in the cool and detached atmosphere of a courtroom, removed in time from the situation in question. Where two views are possible, the court will decline to interfere.
Means, Mr. Fukan, as I have understood this,
My lord,
it says that the court, while examining the matter,
my lord,
will look into the reason
my lord.
recorded.
The veil should be
There may not be a reference to 311. There may not be a reference to the statutory provision, the rules.
Yeah.
That for these grounds,
Yeah.
it is reasonably not practicable to hold the inquiry.
Yeah.
That's the end of the matter,
My lord,
right?
my lord.
But that thing should be there. That the authority has come to the conclusion that it is not required to hold the inquiry. I'll use the word required to hold the inquiry. Right? That is what is 138.
My lord.
This is the heart of Tulsiram Patel.
Not only 138, my lord.
Please, what are the other provisions? Satisfy yourself.
My lord. First, my lord, that's 61, my lord.
Hmm.
Paragraph 61.
Hmm.
My lord,
So here you can sit down.
these 4 or 5 paragraphs will clarify the.
Yes, yes, yes.
Paragraph 61.
Hmm.
page 453.
I got it.
The language of the second proviso is plain and unambiguous. The keywords in the second proviso are this clause shall not apply. But this clause is meant clause 2. As clause 2 requires an inquiry to be held against a government servant, the only meaning attributed to these words is that this inquiry shall not be held. There is no scope for any ambiguity in these words, and there is no reason to give them any meaning different from the plain and ordinary meaning which they bear. The resultant effect of these words is that when a situation envisaged in any of the three clauses of the proviso arises, and that clause becomes applicable, the safeguard provided to a government servant by clause 2 is taken away. As pointed out earlier, this provision is as much in public interest and for public good and a matter of public policy as the pleasure doctrine and the safeguards with respect to security of tenure contained in clause 1 and 2 of Article 311.
Fine. Next.
Now,
Next paragraph.
paragraph 102.
102. Fine.
The entire judgment is near about 150 pages. my lord.
If you want me
So,
to
my lord,
take,
so, my lord,
you want me to take, I'm ready to go through. No problem.
my lord, 102, page 480. May I read, my lord? 480, 102. In this connection, it must be remembered that a government servant is not wholly without any opportunity. Rules made under the proviso to Article 309 or under Art X referable to that article generally provide for a right of appeal, except in those cases where the order of dismissal, removal, or reduction in rank is passed by the president or the governor of a state.
Okay, we
because
got it.
they
It's with
being the
regard to that appeal thing.
My lord.
Next. Next.
appeal, my lord.
Next.
126, my lord.
126.
125, 26, my lord. Last 5 lines, my lord.
The omission to
501.
mention.
The omission to mention in the impugn orders, the relevant clause of the second proviso or the relevant service rule will not therefore have
Fine.
the effect of invalidating the orders, and the orders must be read as having been
Got
made
it.
under the applicable clause.
Got it, Mr. Then next.
Now, my lord, 130, my lord.
Okay.
First few lines, my lord.
I have got
The
it.
condition-
I have read it, Mr. You can go further.
That distinction of not reasonably practicable and impracticable,
I got it.
referring Oxford English.
I got it. I got it.
My lord, now paragraph 136.
You can come to the last line of para 130, page 503.
Page 504.
503.
It
It would
would
not be
also not be
reasonably practical
reasonable-
to where the government servant, particularly though on Progata, so and so terrorizes, threatens or intimidate vacancy. Witnesses who are going to give so and so, so and so, so and so. So
It
and
would
so.
also not be reasonably practicable to hold the inquiry where an atmosphere of violence or of general indiscipline and insubordination prevails,
Okay,
my lord.
then
In the context of, my lord, that particular fact of the
next,
Yes, my
next, Mr.
next, my lord, 136. Regarding that preliminary or anterior inquiry, whether it should
It
be
is next
dispensed.
submitted that so and so. This argument is illogical and in contradiction in terms if an inquiry into the charges is not reasonably practicable, it stands to reason that an inquiry into the question whether well accepted. Next.
Next, my lord, 138, I have already read, my lord. Situation,
Okay,
my lord, to be
but
considered.
Mr.
My lord, here, my lord, in the discipline and service rule, my lord, that rule 10,
10,
it is same
there.
to 311.
I don't know.
And
Akin to
in
311.
rule 15, my lord, the appellate provision is there.
Okay.
He
Now,
has not filed any.
now,
appellate, my lord.
Mr. Fukan, one
And his
question,
retirement age is also over, my lord.
one question. The decision to not go for an inquiry should be there. Forget 311, forget rule 10. but the decision should be there somewhere
Milord,
in your mind expressed
Milord,
in writing. I'm not on the reasons. Only question whether you had arrived at a conclusion that it's reasonably not practicable to hold an inquiry.
Milord, those.
For that, you have placed before me this EC resolution,
Milord,
right? For that. And from there, we can infer that the decision was there. That's your case,
Milord,
right?
Milord, four notices were there, Milord.
Not on that. I am on the decision of your authority that it was not reasonably practicable to hold the inquiry. That has to be there.
Milord, Article.
It cannot be presumed. It has to be there.
Milord, Article 311 to provision that proviso B, Milord. Milord, those.
I'm
indication
not
of-
even on article that you are not going to hold an inquiry. Is it also not required to be said or recorded that no inquiry is required? Dismiss him.
Milord, reasons are required as per.
I'm
proviso-
not even on reasons. I'm giving you the benefit of reasons. You record X, Y, Z, any reason. But that you have to not hold an inquiry. Where is that decision?
Milord, since Milord, the opening lines are those, Milord, four notices.
I'm not on that. I'm on the resolution finally taken and the note put up. Annexure 15 is anterior to the decision.
Yes, Milord.
Anterior 15, Annexure 15 only says, the Honorable VC has already approved the proposal for initiation of disciplinary action against so-and-so for termination of his services.
Prior to that, Milord, those four notices
Forget
have
it.
been indicated, Milord.
That came and got merged in Annexure 15. Now the matter is before the
Executive
EC. Now you see the resolution of these. Resolve that disciplinary action be initiated against Rudra Chandra Das Cook utilizes. It's contrary to what you are submitting. Your authority has said proceed against him departmentally.
Disciplinary action means, Milord, that penalty, Milord. And penalty excludes, Milord, that departmental proceeding excludes in view of Article 311 to second proviso, Milord.
Penalty initiation means, or disciplinary initiation, disciplinary action. Action initiation means to impose penalty. Okay.
Only, Milord, my humble
Look,
submission is that,
look it,
Milord,
look it,
only.
look it. I'll just take down that contention, otherwise I may forget. Mr. PJ Fukan, Learned Counsel for the Guwahati University, has drawn my attention to the provisions of Article 311. Proviso to Article, second proviso to Article 311, more particularly proviso B thereof, and has contended that the authority empowered to dismiss, remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that such authority in writing, it is not practicable to hold such inquiry, the power is vested with the disciplinary authority not to proceed to hold an inquiry and impose appropriate penalty on the delinquent officer. In this connection, Mr. Fukan has referred to the decision of the Supreme Court in the case of Tulsiram Patel reported in 1985, bracketed 3 SCC 398, and more particularly has drawn my attention to paragraph 60, 121,
61, 102,
61, 102,
125, 126,
125, 126,
130,
138,
136,
136 and 138. Also, Mr. Fukan, in view of the said submission, submits that as the petitioner was served with 4 notices asking him to rejoin his services, and he having not rejoined his services, a decision was taken to initiate disciplinary action against him. The matter was approved by the VC, and thereafter a note was prepared for placing before the VC, before the executive committee. The note was thereafter. The note was prepared by the registrar, wherein, after stating the facts involved, had also incorporated the position that the Honorable VC, that the VC had already approved the proposal for initiation of departmental action against Rudra Chandra Das for termination of his service. Full stop. The said note was considered by the Executive Council in its meeting held on 12/3/2020, and therein, in terms of resolution number REC, resolution number R/EC-03/2020/31. It was resolved that disciplinary action be initiated against Rudra Chandra Das Cook, bracketed utilized as beyond establishment branch GU. Mr. Pukan, by referring to the said note, says that this is the waiver of holding. This is the decision for waiver of inquiry process against the petitioner, and this decision being by the Executive Council is binding on all and has to be deemed to be the decision of the disciplinary authority. Anything more, Mr. Pukan? Anything more?
I particularly beg to prefer, my lord, focus on this B regarding recording of reasons, my lord, not recording of satisfaction, my lord. My lord, particularly, my lord, focusing on that, my lord.
Okay, I got it. I'll quote it. Don't worry. I'll quote it as your.
May I read again, my lord?
Quote, Mr. Pukan has laid special emphasis on clause B of the second proviso, and accordingly the same is quoted here in below. Quoting karne ka zarurat nahi, judgment dene ka time mein quote kar lijiye. Anything more, Mr.
My lord.
And has referred and has further emphasized on the words
Is satisfied that for
be-
some reason.
is satisfied for some reason to be
To be
recorded by that
the
authority.
That
in
reason should be recorded, my lord.
Where is that reason, Mr. Pukan?
My lord,
That is what I'm asking you.
that is why, my lord, that page 41, my lord, that termination order, my lord.
No, no, no,
first
no, in
paragraph.
your decision here, that is subsequent. Decision here. This is the decision.
That was the executive council decision prior to that, my lord. My lord, those, my lord, 4 notices have been, my lord, indicated in that.
It is here, Mr. The opening lines of that note says 4 notices. That is why I was trying to extract this from you. I was trying to extract that reason from you. That's why the deliberation.
My lord, my
I'm not
understanding is that, my lord, those 4
Thank you.
notices are the reasons, my lord. And
It is not the reason, Mr. Pukan. If I lay
otherwise, my
down
lord,
that law, tomorrow, I think around 20% of the employees will be without job because they will only write
my
4
lord, just-
notices, finish, go home.
Otherwise, my lord,
That is not the intention of the paragraph.
my lord, we will have to.
While, see, Mr., it's a constitutional provision. Constitution cannot act as a prejudice to any person. That is why the Constitution, while saying you can dispense with an inquiry, it brought in that safeguard.
My lord,
And that is what is interpreted in Tulsiram Patel. And Tulsiram Patel has also been discussed in subsequent judgments. If you read, you will get it.
my lord, this honorable court will have. to
You
leave the-
cannot have it in your mind. You will have to have it on paper. I'm not saying that this court will go and judge your reasons sitting as an appellate authority. No. But something has to be there, Mr.
My lord, this honorable court will have to lift the veil, my lord.
I'll
My
not.
lord, those, my lord, 4 lines, 4 notices, my lord.
Arey, why
Not
should I
mere-
leave?
not
It
mere
is your
con-
paper. You have to satisfy me. If he would have raised such contention, then the question of lifting of the veil would have come. I would have looked into what. Now you have laid bare everything before me.
That entire termination order, my lord, that prelude, my lord, those 4 notices, my lord, it is not mere
We will
formality,
deal
my
it. We have accepted it. We will deal with it now. Either
And,
way, it may come in your favor, it may go against it, but we will deal with it.
retirement, also, my lord, over, my lord, that
When did you retire, Mr. Bhavya?
In this month, Lordship, 31st January 2024.
31st January,
December.
2024.
and when is your dismissal order?
Dismissal order dated, Lordship, on 24/9/2020.
My information is that, 31 December 2023. But
And date of birth 1/1/1964. As per my calculation,
There is no
1/1
dispute on your date of birth?
1/1
Any dispute on your date of birth? No. Recorded in your service book, 1164.
Yes, yes.
Okay, fine. Thank you. Heard Mr. F.U. Barbarian, also heard Learned Counsel for the petitioner, also heard Mr. P.J. Fukan, Learned Standing Counsel, God University. Hearings concluded, judgment reserved.
my lord, that appellate provision, my lord, rule 15, my lord, under discipline appeal.
Appeal will come if I hold that your action is proper, then appeal. 120 or 121 of that judgment. If I hold that your action is not sustainable, he comes back.
My lord.
I filed representation, Lordship, for modification. They have not done it. That is also annexed, Lordship, page 26. The last occasion, I also submitted some decisions.
Thanks to Mr. Fukan, I could refresh my memory with Tulsiram Patel.
Most obliged.
Lordship,
Thank you.
obliged.
Let's sleep it. Sleep now. Continue.
Supplementary list part item 66.
Mr. Bhuya, at how the all seriously matter.
Item 32.
Yes, Mr. Swigya.
Under this matter, your lordship heard it the other day. Regarding that provision of the 2011 Act, my lord.
Abdul Barak.
Yes. You are appearing for Mr. Tomar?
I am for the response 5, UGC.
Okay, okay.
The other day, my lord, I also went to request your lordship regarding a provision of the notification of UGC of the year 2000, wherein UGC says that provision was will find at page, my lord, 25 of that compilation.
This compilation,
Yes, my lord.
20?
25. And the relevant portion, my lord, was will find last page.
Your case was that because you did not have the qualifications, your services were not provincial.
Yes, but as per their.
But in the venture stage, you are the principal.
Yes.
Right?
My case is that, my lord, I was qualified. I was wrongly held to be, my lord.
You say that because you were appointed prior to this subsequent
My lord.
notification, when you were recruited, you had the UGC norms.
My lord.
So that should continue.
Yeah.
Okay.
Possibly kindly turn to page 32 of the.
I have it.
My lord.
I am on that.
My lord. Last, my lord, clause, my lord, clause 5,
When did you have your master degree?
1983, my lord.
How many percentage was?
50.15, my lord.
Okay.
50
So you can have clause 2 also. A relaxation of 5% may be provided from 55 to 50 degree who are passed their master degree prior to 1991.
My lord.
Then 5.
My lord. 5. The minimum recruitment
Yes, this is what I was looking for.
Yes. The persons who were in the university system,
Hmm.
that in their cases, my lord, UGC said the 5% marks should not be insisted.
Hmm.
So, my lord, I was qualified, I should have been provincialized along with the other staff.
Hmm.
That was not done. So, my lord, this honorable court, my lord, in many cases, held that, my lord, those persons who were qualified, not provincialized, they should be held to be, my lord, deemed provincialized. In those cases,
That argument with regard to Dilip Das is doubtful. Dilip Das went the full length. You get my point?
my lord,
Dilip Das case, his case went the full length under the 2011 Act.
my lord.
Only that notification was to be issued. Court said once under 10(4) his government has approved his post. Notification has not issued. Enough. That is ministerial act. That is why Dilip Das. If you can come to Dilip Das. Para 9, page 67 of your that compilation. 9, 10. 9 and 10.
My lord.
Then 12. You should read para 12 with para 9 and 10. So this is your stand.
Yes, my lord. So, my lord, even if, my lord, I am not deemed to be provincialized,
If we hold that that UGC norms in quotation
my lord,
means what you had when you were recruited,
yes, my lord.
because you were recruited in a college affiliated to the university.
My
So you are in the university system.
lord.
Then we'll have to come, maybe we'll have to direct the authorities to have your case considered under the 2017 Act. If we hold what Mr. Gogoi is trying to project, then nothing. If you are eligible under the 2017 Act, you will get it. But whether you will be the principal from that time or not, that would be a question which the government would decide. That's the issue here.
But only difficulty is that my petitioner has retired in the meantime.
Right. Okay, we'll see.
31/10/2020,
31/10/2020.
my lord.
This case is of 19.
Yes, my lord.
Let's see how we can help it. Yes, Mr. Gogoi.
Lordship. In this case, Lordship, we have filed detailed affidavit, Lordship.
I've seen it.
And so, my lord, may I kindly come to page 655 of the book, Lordship.
Hmm.
Four-T, Lordship. It's a 2011 Act, Lordship.
Hmm.
4-3.
Hmm.
The services of teaching or non-teaching employee in a Bhensa education institution up to higher secondary level
Hmm.
shall be considered for provincialization only if they have the requisite academic and professional qualification prescribed by the relevant rules at the time of the initial appointment.
Hmm.
If that person's lordship hold a required professional and academic degree, lordship,
Hmm.
at the relevant point of time when he was admitted in the secondary school, then their cases should be considered on the basis of that degree, lordship. As per this lordship proposition, lordship. Then my lord may kindly come to second part, lordship.
Hmm.
In case of employees of a degree college,
Hmm.
they must have acquired such requisite educational as well as professional qualification as may be determined by the University Grants Commission for time to time.
Hmm.
That means, lordship, when the consideration took place, lordship, the academic and professional qualification which fall in the field, lordship, that should be considered for, lordship, provincialization, lordship. It says that from time to time, lordship. In case of employees of a degree college, they must have acquired such requisite and educational qualifications as well as qualification as may be determined by the University Grants Commission for time to time, lordship.
Okay.
If Lordship, the intention of the legislature is that the qualification which acquired by an incumbent at the point of the initial appointment, then Lordship, the legislature shall not or may not add this provision, Lordship. Otherwise, it
Sir,
will go by the,
Soikia, when was your college provincialized? Order
14, my lord.
otherwise it will go by the proposition of the legislature in the
with
first
effect from
stage.
1/1/2013.
My lord,
Give me that date. Yes, Mr. Gupta.
Lordship. If the intention is that, Lordship, the persons who acquired the qualification at the time of initial appointment, then Lordship, that further clarification is not required. Then it should be the
26/5/2014, my lord.
With effect from
With effect, my lord.
1/1/2013.
Yes, 44%. What? 14/8/2013. 14/8/2013.
Huh?
14/8/2013.
Mr. Gogoi,
and Lordship.
understood. I understood what you have indicated with regard to two parts.
Lordship.
If it is school, initial, if it is college.
At the
Fine.
time of consideration.
Now come to the proviso.
Proviso. That's why proviso should be read as a whole, Lordship. It should not be read as a part, Lordship. So, Lordship, that other day we are reading up to 4 lines of the proviso, Lordship. The later
Go ahead.
part we have not.
You take me ahead.
So, Lordship, provided that if an employee is required to acquire any prescribed academic or professional qualification, service of such employee may be considered for provincialization if otherwise eligible, Lordship. But in such case, the provincialization would be subject to acquisition of such prescribed qualification within a period of 5 years from the date of coming into form of this coming into force of this act, Lordship. And Lordship, during this intervening period, he may continue to work under the existing terms and conditions under which he was working until his service is provincialized, Lordship. There is a gestation period is there for 5 years, Lordship. In that particular period of time, Lordship, that particular person should be acquired the required qualification prescribed by the statute, Lordship. And for that gestation period, Lordship, he should act as a employee as he was act in the venture stage, Lordship. In case of his failure, that part is not necessary, Lordship. That's why, Lordship, the proviso should be read as a whole, Lordship. If that gestation period, that particular person acquired, Lordship, then that will come, Lordship.
Got it.
Then that will come. Here, Lordship.
Yes, Mr. Yes, something more.
That will come, Lordship. That is the issue. Otherwise, Lordship, 2011 Act was already struck down, Lordship. And I will rely to judgment of the Honorable Apex Court, Lordship. I will just hand over it, Lordship.
You just give it to me. For that purpose that when it is not there, you can even.
Lordship, just I pointed out the relevant paragraph, Lordship.
Just mark it on the top.
Mark,
portion.
I will
Just write it in the top.
Yeah.
Yes, Mr.
Just I pointed to judgment, Lordship.
You just mark the paragraphs there. Write the paragraph.
I will write it.
You write it.
Lordship. Then I am relying, Lordship, the CBI versus RK Kisu's case, Lordship.
That you told me on the last
It is a
occasion.
constitutional based judgment, Lordship.
I know. Yeah.
And other Lordship, mark with it.
Mark code.
Mark with it. And Lordship, other Sridhar Kumar Rukam case, Lordship, he judges bench. And regarding time to time, Lordship, the one full bench judgment of Honorable Punjab and Haryana High Court, Lordship, which was also relied by the Honorable Apex Court in other cases in Gurudwara Prabandhak Committee. That judgment I will rely.
Prabandhak Committee, huh?
That full bench judgment. It was a
I think you
well-known
placed it on
judgment.
the last occasion. Guru that.
In the Gurudwara, 2 judgment is there. One is full bench judgment regarding that time to time clarification.
Another one is a Supreme Court judgment.
Other was, Lordship.
I think you placed the Supreme Court judgment last
That
time.
part and that part, Lordship.
What does it say? Time to time?
Time to time, it says that at the time of consideration. Even, Lordship, today, my Lord have take one decision, Lordship. By evening, my Lord may not take the decision also, Lordship. This is the interpretation of the Honorable full bench of the Punjab and Haryana.
That will be judicial impropriety on my part.
Just in the executive side, not for the judicial side.
No, no, good.
In the executive side, Honorable Punjab and Haryana High Court clarified that even one decision was taken in the morning, in the evening, he may not take this decision also. At the evening, which law is prevail? That will be
I
lordship.
got it. I read it. Yes.
Lordship, I will hand over that judgment.
Yes.
And my lord, I will not burden
Mr.
our judgment, lordship.
Mr. Samua, what is university system? I didn't understand this when I was that side, so I'll now understand it after I've come this side. What is university system? In context of your regulations that come in from time to time. Because it hinges there.
What the initial understanding that is, the moment your lordship has asked this question, what is university system? Means a college when it is affiliated to an university. And maybe a college constituent college under the same university. So when it is a different college under the governance of a different body, but affiliated to a university, then perhaps it is called university system.
Mr. Bugoi, this definition of university system, which he has given, you are with the UGC norms, right? Total. UGC norms, whatever is coming, total is applicable. Now that's not in dispute.
That part also, lordship.
Huh?
That part also, lordship, not settled by the honorable appeal.
Forget it. That whole. No, I'm not on that. I'm not on that.
Lordship.
The UGC says net slate, you are bound to follow.
Bound, lordship, that is bound, and 55%.
But the interesting portion, I think, which may have been missed out, that university, that UGC notifications has a clause that persons already in the university system need not have this. So, if we hold that the petitioner is in the university system, 2011 to gone, 2017, and with that clause, time to time is interpreted, what would be the effect?
Then also not, lordship. UGC never exempted the 55%
No.
of marks.
No,
No, lordship. No.
UGC exempted it, Mr.
Yes,
He has brought on
Where
record.
it is, my lord?
It's a regulation of 2000. UGC regulations 2000.
But to which page your lordship is referring? my lord?
25, Mr. You just give it to me.
25?
He'll give you. It's not UGC.
In which clause, my lord?
You come to page 32 there.
Yes.
Come to clause 2. Notes.
Clause 5.
Notes 2. No, notes 2.
Two.
A
Notes.
relaxation of so and so, 55 to 50 of the marks of PS, so and so, forget it. 5. The minimum requirement of 55% shall not be insisted upon principals, professors, readers, so and so, for the existing incumbents who are already in the university system.
It is for existing incumbent. He is not existing incumbent.
No, he is in the university system. He is in affiliated college. He may not be under you, but he is in affiliated college.
It is not a provincialized college, lordship.
Forget it. Even a private university is under the university system. A private college.
We are bound by the lordship statute. Statute says that time to time, and it was also clarified by the Mohan Singh case, lordship, in the latest judgment of the Honorable Supreme Court, lordship.
Mr. Gogoi,
Lordship.
try to understand. I have to write a judgment.
Lordship.
Now this time to time,
Lordship.
can it be in air? Only the qualifications I'll see, I'll not see the other part.
Lordship.
I'll only see the qualifications, I'll not see the other part. The wording is,
Lordship.
as well as educational as well as professional qualification as may be determined by the University Grants Commission from time to time. Now, while University Grants Commission is determining it, it is also providing some mandatory relaxations. How do I
That part is not there in the present relaxation lordship. That is not there. Even lordship said to interpret it regarding existing employee lordship. Whether he should be considered existing employee.
I'm not on that.
He-
Whether he should be considered as a person in the university system.
He,
He has made a statement,
It
Mr.
says that lordship, the UGC qualification says that lordship, he should be an existing employee lordship. Whether he has come under the definition of existing employee lordship.
Are existing incumbents who
exist-
are already in the university system.
Already in the university.
It does not say government, non-government. You are
Not-
confusing, Mr.
No.
I'm not on the provincialization part. I'm on the UGC norms part.
Those who is. The minimum income shall not be insisted on the principal professor area. Registered as an deputy university, existing incumbents who are already. My lord, may kindly peruse again, lordship. The minimum requirement of 55% marks shall not be insisted upon for principals, professors, and readers. Yes. Five.
You read the whole thing.
Lordship, for the selection of properties.
No, he joined get a question.
Here, lordship, we should, lordship, read it from lordship 3.5.0, lordship.
You read 5 first.
5 clause, lordship, 5 clause is
You read
related.
5, that last line.
Last line, lordship, it is, I will again, lordship.
No, read 5.
Eh.
No, I'm not in a rush in this.
Lordship.
However,
Minimum Lordship.
these marks should not be insisted upon for those entering the system from outside
Lordship.
and those at the entry point of so and so, so and so, so and so.
Assistant registrar, lecturers, assistant registrar, librarians, and assistant directors of physical education, lordship. Here, lordship, it should be read with, lordship, the qualification for the post of principal, lordship.
I know that.
3.5.0.
I know that.
3.5.0 says that,
Mr.
lordship.
Gogoi, I'm giving you that, but this is also in that same document.
This, lordship, we have to read it conjointly, whether lordship accept or not, it is.
No, I can't read it conjointly because that is an exception given.
This exception
Yes,
is.
conjointly we will
This-
read.
This exception is in respect of qualification for the principal, where it says that it should be the 55% of marks, lordship. If one person who is already in the university system applied for the principal post, lordship, then the 55% of marks should not be, lordship, insisted upon. It is the intention of the legislation.
Now, whether he is in the university system.
No,
or not.
lordship.
No.
No.
But the UGC says,
Not, UGC then clarified, lordship, whether then.
UGC statement, opening statement is that he is in the university system.
Otherwise, lordship, the qualification which was 5% relaxation to those persons were already in the service as the professors or other things. Then the qualification which was prescribed for 55% of marks, that should not be insisted. It is the intention, lordship.
Yes, Mr.
This is the intention.
Samua,
Otherwise also. at this
you are the
stage,
author.
lordship,
Whether university system means anybody,
Everybody
any
can-
college or only government college.
First of all, my lord, my initial response is too much noise.
Chalta hai. Then,
My lord, my initial response will be, my lord, to the whole thing. I have to understand what is university system. I'll have a talk with the
Come back.
UGC officials.
come back.
My lord,
And if you want an answer to the argument you are trying to develop, read that provision once more.
and my lord, in my respectful submission, my lord, the person joined, to my understanding, he joined in the year 1988. So perhaps regulation 2000 is not applicable for him.
I'm not on that. I'm not on that.
No, this
He says
explanation-
time to
no,
time.
No, my lord.
Time to time.
No, my lord, this
If
point
time to time,
notes,
that logic is applicable.
You get
Yeah.
me that regulation that was there in 88? Same
Yes,
regulation would be
yes,
there.
I'll provide to him, my lord.
You
Not
provide
at
to
this,
me.
at this moment, I don't have.
You provide it to
I
me.
I'll
have-
provide him.
I have lost, I will provide.
You have it with
I
you.
have.
Now-
Now I have provided the.
Just from 88.
I will provide this. Otherwise also, lordship, just one thing I have pointed out, page 42, lordship. Page 42, it's a order of 2013, lordship. Where is the unqualified teachers, lordship? The list of unqualified teachers is the number 1, lordship. When he is approached his honorable court in 2019 after step down of the act, lordship.
Mr. Gogoi,
Lordship.
I'm not interested with the peripheral matters. I want to go into the meat.
That's right, Lordship. I just pointed out one thing, Lordship.
Yes, show me that 88.
Lordship.
Well, let me fix it another date, my lord.
I'll do that. First.
87.
The head
Lordship.
is blank, so let me store something.
Well, it's full.
It's blank. Coming from that side, everything deleted.
Formatting. কোনটো পালা তুমি?
This is followed, Lordship. 87. Lordship.
আৰু কপি আছে তুমি ওলাচোন চোৱা। মইয়ে দিছিলো তোমাক।
আপুনি ক'ত দিছিল?
এদিন মোৰ পৰা চব
বস্তু আপোনাৰ থাকিব। হ'ল।
মোক দিয়াচোন চব।
Then 91.
No, Lordship. 87 in Ministry of Human Resource Development notification, Lordship. It was followed, Lordship.
Forget that 91 is the regulation.
The 87 prescription has been amended.
87.
87 prescription, what my friend is relying on, that has been amended. I have brought on record in the compilation, my lord, page 40.
87, there is, Lordship. 10, Lordship. Channel number 10, Lordship. Channel number 10, Lordship.
Just a moment. Yes, where is serial number 10?
10, Lordship.
Okay, read.
That serial number 10.
No.
Serial number 10 was deleted.
It is when petitioner was appointed, that is the Lordship. If petitioner insisted that at the time of
When is
appointment.
the date of appointment?
Lordship.
8 August 88. 8 August 1988.
88.
My lord, after the deletion, my lord.
This deletion is of
22nd
July.
July 88.
So 10 does not figure. Okay. You give him a copy of your that compilation. No. Give him a formal copy. You'll have to give him a copy. Give him a copy.
I'll be.
Both.
My lord.
Interesting.
Lordship.
অলপ খালি কোনদিনা আছে এইকেইদিনত? নাই।
February, not in the.
পাহৰি যাম ন এইটো কথা। হ'ব 8 তাৰিখে দিওঁ। 8 তাৰিখ তাৰ কাৰণে খুব লাকি হয়। একদম খুব পিছতে 8 তাৰিখ বিচাৰি আছে।
Thursday.
Thursday.
Lordship. Oblige.
Help this confusion to be cleared.
Lordship.
But I think there is something.
And we also.
He may not get the relief.
But some gray area will be set.
It's there.
32
This
years.
university system has been troubling me for a long time.
Yes, sir, for
What is this
32
university?
years.
Huh?
Yes, sir, for 32 years.
You may not. It may be a case of operation successful patient then, because 2011 is not there.
Authority, my lord, to
But
keep-
we will then require as an exceptional measure under 2017. From a date, at least you get some money.
That part I will satisfy, Lordship.
Milord, that definition of university system, Milord. It
Yes.
will be, Milord, the crux of the matter, Milord. Milord, Guwahati University affiliates private college also,
Will it be outside the university system?
Milord.
That's my query.
They are the voters, my lord. I'll rely on the voter list, my lord, of
Of
the
the-
principals of the Guwahati University. I am one of the voters.
University.
I am one of the voter.
So, Milord, that university system, Milord.
So, Mr. Samuha,
My lord, I'll come.
Mr. Gogoi, and Mr. Fukan, if you can be of any help, please be here.
Lordship.
Milord.
I think this is an issue with also you can put in throw in some light.
Milord.
The statement you made, that's the crux.
If lordship fixed it little bit later,
No.
no, I can come up with
No,
an
no.
affidavit then, my lord.
No. 12. I'll forget.
12 for 8.
Very low retaining capacity.
No, I understand. It is the 12 for 8. 8.
Eight. Only take a phone, telephone. It's an illegal question only. No factual interpretation.
I'll get a mail then.
Most of them.
On after detailed deliberations held in the matter. No. Upon hearing the parties to the proceedings at length, Mr. Somoha, A. Somoha, Learned Standing Council UGC, and Mr. K. Gogoi, Learned Standing Council Higher Education Department, submits that they be given for the week's time to clarify the queries raised, queries arising in the matter. Also, accordingly, list this case again as a parted item on 8/2/2024.
Publish.
Judgment came to the report, Lordship.
এই জাজমেন্ট কেইটা দিছিল সোমাই দিব দেই সোমাই দিছো
Lordship, Lordship.
এটা অলপ পাৰিলে ওপৰত থাকিলে ফটো হেৰাই নাযায় নহলে একদম সোমাই দিব অলপ
Item 33 and 34.
May it please, Your Lordship.
Yes.
Your Lordship, I for respondent number 8, Your Lordship.
Hmm.
I filed my affidavit today, Your Lordship. We have served them a copy and we filed it also. Your Lordship may have it any other day as per your convenience, Your Lordship. Or if they want to file rejoinder, that.
On the prayer of the parties, list this matter again on 19/2/2024. The pleadings
Well,
filed in the matter.
I'm for the UGC respondent number 6 in.
Both, I think. No, I'm taking.
Yes, what do you have to say?
Well, I'm respondent number 6 in writ petition 6285
Hmm.
and 4 in writ petition 7021.
Hmm.
Let me record our presence.
Okay. Also heard Mr. A. Somoha, Connect Council for the party Namita Ludu, for the UGC. By the next date fixed, the parties shall bring on record their respective pleadings. We'll give some more time. List this matter again on 4/3/2024.
Yes, sir.
Tutate, beleg order might.
Uncle.
Same order. Tutate.
Public.
You are appearing in both the cases, Mr. Sharma?
Yes. Item 35.
Yes,
Take
Mr.
Some more time, my lord. That verification process is also, my lord, on the way, my lord. Almost on the
Complete.
path of completion, my lord.
Okay. Mr. PJ Fukan, Learned Standing Council, Gaudi University, submits that the verification process as mandated in the matter is nearing its conclusion and the outcome thereof would be placed before this court on the next day. Also, accordingly, list this matter again on 15/2/2020.
Most obliged.
Mr. Fukan, see to that on that day it's taken. Either give us the
Item 37.
yes, Ms. Ahmed.
The petitioners, juniors, your provincial lordship,
To file affidavit, my lord.
respondent of 5 and 6.
Have appeared.
Yes.
5 and 6 has appeared. You are there. Okay, why should he not be given dignity?
Lordship, who is standing together for filing of affidavit?
Okay, you also want that.
Lordship.
Joint prayer.
This is not the.
The respondents are afforded a week's time to bring on record their affidavit as a last chance. In the event on the next date fixed, affidavits are not brought on record, matter would be proceeded basing on the materials available on record. Also, list again on 13/2/2024.
Deeply obliged, my lord.
Not actually, but
Timing item 64.
Mr. Nath, have you seen the brief?
Yeah, I have seen
What is it?
it. But the.
Because what I find, I just want a clarification, that they are not there. 2 days I wait.
Lordship.
That committee had recommended him as the LDA.
Lordship.
And with the prescription that he will continue as LDA. That's the norm,
Lordship.
how it should be. But you made him a Khalasi.
But in the affidavit in opposition, we have stated that there was a writ petition order. In that order,
That is being stated. What is that?
But I tried to get that order.
I also, I could not.
But in paragraph 4, my lord, we have stated, but here, my lord, what I find, the person, he has retired in the year 2013. And he has got all the benefits. my lord. I got the release order today. It is with me, my lord.
What is that? He got benefits.
He has obtained the benefit as secretary, as Sahayak. He was appointed as Sahayak, he retired as Sahayak. So, my lord, after his retirement, in 2013 itself, my lord, he retired. Although
You
in
mean
the-
to say between that order committee's direction, there is some orders of this court?
my lord, the paragraph 4 of the affidavit in opposition.
I've seen it.
Lordship. Well, Lordship may give me, my lord, if can be taken on Monday or Tuesday, my lord. I'll get the order, copy of the order.
Get it. Because if man is entitled to something, we'll give it to him.
Correct.
Have it on Monday.
My lord, tomorrow is a holiday.
Tuesday.
On Tuesday. Lordship.
On the prayer of Mr. Dina, Standing Council, APDC,
APGCL.
APGCL,
Lordship.
lists this matter again on 31,
Lordship.
2020.
Lordship.
You can, it'll be in the top of the list only.
I'll pray for
Just
that.
give me that.
I'll pray for that. Lordship.
So that's something which is troubling me.
Super.
If that committee's order has been upheld, he becomes an LD.
Our stand is that court has observed in the order.
But that is very, very vague sort of a statement made in the affidavit. Neither here nor there. Get me that order,
They said that order, High Court has given the order to the committee.
committee.
I'll
Just get that.
I'll come up. Problem.
What did you?
Timing item 16.
He is on the next court number 27. He's coming, my lord.
You start. Order is dismissed.
Good.
5 times I can't keep on calling a matter. 2013 matter. Yes,
President, the council of the respondent is also 27.
I'm not interested.
At the briefly.
It's your case, you place. If you can succeed, fine. I'll give you 10 more minutes. 10 minutes, please. Serially, Matito.
Item 28.
Yes, Mr. Bhuyan.
My lord, the judgment is of my lord WPC 3038 of 2021, my lord.
It's that madrasa matter, no?
My lord. My lord, in fact, this petition is structured in something in a different manner by the students, my lord, and the policy, my lord, which has been adopted by the government, that they will be given the opportunity to complete their course curriculum. But that policy, my lord, has not been complied with.
Yes, what does he say?
My lord.
Is there any policy?
Yes, my lord, it is in their notification at page 256, my lord.
Miss D. Musahari, Learned Standing Council, Standing Council, Education, Secondary.
Secondary.
Secondary Education shall on the next day place on record instructions as to the contention made by Mr. Bhuyan that the respondent authorities have not followed the prescription as contained in
In the notification dated, my lord, 12/2/2021.
page,
That 12/2/2021, my lord, page 256.
you mean to that original notification, 12/2/2021.
My lord, this is the original one, my lord.
Where?
My lord, it starts at page 258, clause 9, my lord. All students presently
With
studying.
regard to
My lord.
Hishami? In clause 9 and 12 of the notification dated 12/2/2021. The aforesaid instruction, the written instructions with regard to the said contention of Mr. Bhuyan, he placed on record on 15/2/2024 by Ms. Soils.
My lord, the
52.
order copy may be a
We have
part,
52.
my lord.
Item 39.
Oblige me.
Yes, Mr. Ahmad.
Yes, my lord, the petitioner's name was not recommended by the, my lord, DSC lordship. My lord, as under section 14, my lord, it may be disposed of lordship to file.
You want to go on 14, withdraw this, go. Who am I to ask?
Lordship. Otherwise, DSC did not recommend lordship, section
So?
14, there is provision lordship. Now, only 2 teachers have been provincialized lordship. My lord, as per norms, my lord, 3 is entitled to be provincialized lordship. The petitioner
You withdraw
was
this, you
dropped
go.
out.
It's up to you.
My lord, then it may be decided, my lord.
You decided we'll ask them to.
Section 3, my lord, 3 teacher, at least 3 language teacher, science and my lord, social science.
Show me whether you are what posts have been filled up now?
No.
Where is the
2
provincialization?
teachers, my lord. Provincialization order, input order is at page 38.
No, 38 here.
Lordship.
There is no 38 here, Mr.
33, my lord.
39 is the,
No, 39 does not show the post.
39 is the least lordship. Kasaripam Ami. This is a
What is the name of the petitioner?
petitioner is a, sorry, I'm sorry, lordship, this is a,
33 please.
yes, lordship. My lord, this is a, only 2 teachers, Mofizuddin Ahmed, Azhar Ali Khan.
What is the name of the school?
School is lordship, Kusia, Jor Shimli Puran Kusia Mi Madrasa. Jor Shimli
Page 34.
lordship.
Huh?
This is 34 lordship. Serial number 71.
72, yes. Mofizuddin Khan is what?
My lord, it is not indicated what is, sir, my
So
lord.
then how can I do that?
My lord, in the my lord, DSC recommendation, it is there, lord.
What are you?
I am, my lord, Arabic teacher.
If I don't know who the other teachers are,
My lord, in the
if there is
recommendation.
already a language teacher in, then
Recommendation, kindly see, lordship.
where is it?
My lord, page 32. 32. Mofizuddin. 3 teachers were recommended, lordship. One was Azhar Ali PhD Science.
No, it's not there. Science teacher, yes.
Yes.
Then headmaster,
One general teacher, lordship.
then one general teacher.
So the
whether,
petition
what are
will be
you?
directed to be considered.
See, if the general teacher is a language teacher, how can, if it is shown as 80? Because I find that it's all 80 everywhere.
The petitioner is also a language teacher.
Have you made a statement somewhere that this person is not a language teacher? That Faizul Haq Mondal is not a language teacher. Have you made a statement somewhere? No.
My lord,
Okay, I'll find it out for you. Wait.
as regards what, lordship?
So page 7, para 8. Tell me who these persons are.
My lord.
Where is this respond number 5 and 6 in the plea in the
Yes, no,
question?
there's no response, private response.
And then why have you written this para 8?
My lord, it may be wrongly.
Copy
my lord.
paste.
Wrongly, lordship, it is.
Then,
It is wrongly.
Huh?
Read.
if this is the statement, there is already a Hindi teacher.
Anyway, it may be directly, my lord, disposed of.
I'll
by
not do it.
Section 14 law.
No. With this statement, how can I? Why should I trouble somebody now?
Yes, so private response is not there, lordship.
Then, but your para 8 says.
My lord, from South America, it was come, lordship.
Not somewhere. Wait.
Yeah, maybe allowed to correct it.
How can you correct it? File an amendment application. Amend this.
Lordship, this is respondent number 5 is not there, Lordship. It was, my lord,
It's not even connected to your writ petition.
it was wrongly, my lord. Well, my lord, I will be allowed to correct
How?
by
You
deleting.
File a
the-
vacating, you'll have to file an amending application, deletion.
My lord, additional affidavit, Lordship, I will find clearing this.
No, no, no. No additional affidavit.
By clarifying, Lordship.
No, no, no. Will not accept that. You withdraw this. Go there.
Then I'll file amendment petition, Lordship.
Fine. The petitioner is permitted to file an application for amending the inadvertent error occasioning in paragraph 8 of the writ petition, wherein references have been made to private respondents, whereas in the present proceedings, there is no private respondent impleaded. Full stop. The petitioner to file appropriate application for correction of this said error, and it is thereafter only the present petition can be taken forward. List this matter again on. When do you want it?
February,
February,
second week, Lordship.
third week, 13th,
Lordship.
on 12th, on 12/1/2024.
All right, Lordship.
Item 40.
You just correct it, I'll dispose it of.
Lordship.
Same day. Same day dispose. Get it?
May pleasure, Lordship. Lordship. This item may be called as the last item, Lordship. Youngest Council is in election court number 3, Lordship.
On the prayer made by the, what is the issue?
Actually, I am not aware about the case, Lordship.
On the prayer made on behalf of the learned council who is stated to be busy. List this matters again after 4 weeks on a date to be fixed by the registry.
Date may be fixed, Lordship.
No date.
Item 41.
Youngest Council is in election court number 3.
Fine,
There is item.
fine. I can't, I have, whenever he is free, he'll come. I can't wait for him. Can I?
Obliged.
2 weeks.
My pleasure, Lordship. Lordship, the matter here pertains to regularization of the services of the petitioner, Lordship. And also to pay his arrear as well as current salary. Lordship, the department has not filed their affidavit. Lordship, the headmaster have filed. The department principal have filed, Lordship.
22 matter. Heard Ms. Talukdar, learned counsel for the petitioner. Mr. B. Kaushik. You are for?
Respondent 4.
Okay. Mr. B. Kaushik is given further 3 weeks' time to bring on record his stand of the department in the matter.
Otherwise, my lord,
List this matter after 3 weeks.
it's a provincialized school, my lord. He was
Honorary teacher, I've seen it.
honored, appointed by the managing government.
And what does the college say? Affidavit?
Headmaster says that
Yes, what is your stand?
In the post of advanced service, my lord. The advanced service post.
No, 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 sound.
Since 2005, he has been continuing. Pursuant to SNC resolution.
the school authority has no.
Yes, Mr. Goswami, how have you appointed him?
They cannot allow him to.
Because there is no post.
Who has appointed him?
Teacher, that is why you.
Where is your appointment order?
Lordship, there was a resolution at page 17, Lordship.
17.
The resolution is at page 17.
Okay. Same principle. Today also.
Jyotish
No.
Chandra Dekha was the principal.
Jyotish, now the
Jyotish
change,
Chandra Dekha.
now changed.
And the page
I have
19.
been
is the appointment
continuing
order.
since 4/8/2018, my lord.
Now tell me, what right? She's asking for regularization and you are supporting. Pay her from your funds. We'll observe. From today onward, she'll be paid the salary of an assistant teacher,
We have
postgraduate teacher,
disclosing our stand.
The
now.
subject teacher.
subject teacher in terms of the government ROP. Pay her. Principal, managing committee. I'm pausing, pause, you pay.
That will be.
Then who authorized you to file this affidavit contrary to the position? You are a government servant.
My lord.
You are not covered by the rules.
Malad, I am governed by the rule,
Then
but I am disclosing that pursuant to the SMC resolution, he was appointed in 2005.
How can the SMC resolve, my lord, first?
come to para 9.
Yes.
Para 9.
Well,
Oh, he has been continuing since.
No,
1
para
April
9.
2005.
Then you come to para 13.
of the writ petition?
No.
No, affidavit.
So you are saying that the government will one day, you are exploiting her or him, him, exploiting him,
Malad.
slavery.
Malad.
We are taking you, tax, you explain, next day, affidavit. As to why you will not, the school authorities will not pay her the minimum of the salary of a subject teacher. On the next date fixed, Mr. U. Goswami, UK Goswami, shall respondent, appearing for the respondent number 4, shall no. The respondent number 4 shall file an affidavit on the next date fixed, wherein he shall explain as to how and in what, how and under what power the services of the petitioners are being utilized by the school without paying her any salaries. Admittedly, the petitioner is a honorary teacher in the school, and it is settled law that after provincialization of schools, the managing committee is not empowered to engage any person on honorary basis. The respondent number 4 shall also in this affidavit disclose as to the shall also disclose as to why directions shall not be issued by this court directing the school managing committee of the school and the principal to pay minimum of the scale of subject teacher to the petitioner. List this matter again on 8/2/2024. Oh no, 7/2/2024. You will get your salaries, don't worry. College authorities will pay you. Come with your answer. Huh?
I just.
You are exploiting her services, giving her a hope,
just says
and
that,
your affidavit also
I have been
raises her hope.
since 2018 only, madam.
Why
was appointed way back in 2005.
Okay.
I am
Whoever
saying
is
that,
there.
he has been continuing since 2005.
You,
I'm
your
not-
president, nowadays president, oh, it's big post. Everybody wants to be president.
I'm not-
President will pay 50, you pay 50. Give her full pay. You know. List this matter again on.
Seven.
Kundina issue?
7.
7.
No. Let them file, let's see.
My lord.
File an affidavit.
Item 42. In this case, your lordship asks to file affidavit, my lord. So affidavit is ready and we send it for vetting.
Mr. Talukdar, B. Talukdar, Learned Council submits that the affidavit on behalf of the department is ready, and the same would be filed by the file in 7 days' time. Also, list this matter again on 7/2/2024 for further orders. Further, list this matter on 7/2/2024.
Highly obliged, my lord.
Itu kata dia. Boleh disitu. Lika. List this matter again on jitu date issue 7/2/2024 or further orders.
Highly obliged.
Date the same. Order to available.
Timing item 60.
Mr. Kaushik, we are not passing that order. Tell Mr. Goswami. Otherwise, he'll be palpitated. We have deleted that. We'll hear the matter on 7/2. Tell him. Yes.
Apologies, my lord, for not being here on the.
No, you should not have come. I would have dismissed it. That's all. What apology? Now you have come, I'll have to open it. Okay. Yes.
My lord, the matter relates to the grant fixation, correct fixation of pay scale, my lord.
Not correct fixation of pay scale. You want to take benefit of Vishwakarma and what is that matter I appeared?
Yes, my lord, P. Chandran.
Huh?
P. Chandran, my lord.
P. Chandran. Yes, you want to take advantage of that.
Not
Will
only
it show me that the diploma holders are getting it?
my lord, that diploma holders are getting it, that is an issue before the Delhi High Court at present, my lord. And some part of the other judge.
Diploma holders are not getting it.
No.
The judgments of this court categorical. Diploma holders are getting it.
Correct.
So you give it to
My
them.
lord, before coming to that finding, lordship will find that this honorable court is also held that.
No, I cannot. I will have to hold that the post is a diploma post.
Yeah, it is.
It may be. But in all those cases, the diploma charge mechanic was being given.
Yes.
So the non-diploma following that fishery, my Lord Justice Ranjan Gogoi's judgment, following that, this court passed the order. Last occasion when this matter was considered, submissions were that diploma holders are getting it.
Yes. We both moved an appeal.
So this,
No, we moved an appeal, both parties.
that this
was a
court
wrong,
passed it,
that was a
judicial
wrong,
wastage of time.
that was a wrong submission is. We,
Your submission,
that was what was recorded by the learned single judge. We both moved in appeal.
fine. The
Respondents
learned
and
single judge
petitioners.
cannot record in air. You had submitted, that is why the recording came. Maybe you were not the counsel. You were
Otherwise,
not
but-
the counsel.
but
Mr.
petition-
Chakraborty was there.
No, Lordship, I also
No,
entered.
Mr.
late.
KR
Oh, you also was
He
not
also
there.
came late.
was there. We
But
both
the
came late.
respondents and the petitioners were there.
Both are substituted.
So just satisfy me, without that diploma holders getting it, how can I give it to you? Yes, Mr. Chakraborty. Yes,
Possibly
what do you
maybe
want?
sometime on that, because I have to go through the judgments which will show that the intention of the government in adopting the pay scales was to give a pay scale to a particular post, not
know
to
it.
the incumbents therein.
I know
Therefore,
it.
that particular post, which was not given that particular pay scale, has the minimum qualification of diploma.
Wrong,
And there it is,
wrong.
if I may show.
It was charge mechanic diploma holders were given that 5,000, 8,000.
But that is what I'm saying. What is falling from lordship is correct. That is those cases. But in those cases, the reference has also been made.
Why should we adjudicate? It's pay parity. They have taken a decision. Why should
No,
we
but
come in?
not, well, that particular post with the diploma, which requires a diploma, is entitled to a particular pay scale,
Okay,
has been held by this court.
okay. The
Sound-
diploma
sound-
holders, one second,
My
the
lord.
diploma holders who would be first attracted by that principle have not been given.
Well, they are also before the Honorable High Court in Delhi.
If there is a
And we are
decision
also-
there, if there is a decision there, then you come back with those decisions we'll give you.
My lordship will.
Because they are not
It is-
before me.
It is not.
They are
because-
not before me.
It is not because only the diploma holders are entitled that we are asking for it. Our case is that since it has been given to all posts which require a diploma, and ours is a post also which requires a diploma. In that view of the matter, this entire post should have been given the pay scale. Lordship will kindly have that part of the judgment, my lord.
Come to your prayer.
My lord.
Come to your prayer.
Yes, my lord. Admit the petition, call for the records issue
Forget it.
by
It's 50.
the pre-revised pay scale of 5,000 to 8,000. Revised pay scale of rupees 9,300 to 34,000, along with grade pay of 42 shall not be extended in favor of a humble petitioner with retrospective from the date of their appointment as radio mechanic for all purposes, including pay fixation and actual benefits, or at least effective from 1/1/96. For all purposes, including pay fixation and actual benefits with effect from 1/1/06 and after hearing the parties. Now, when the finding of the court is that that particular post is entitled to a particular scale, and the respondents denying it to us only because that none of us were diploma holders when we were holding that post. That is what
I appeared in this matter. That will not be. I can take up.
you, lordship appeared in a matter which was decided earlier and which related to a different set of
Yes, Mr. Chakraborty.
petitioners.
Lordship, we have made clear in our paragraph 8 of our affidavit, Lordship.
Hmm.
It's quantitatively and qualitatively different. They are not non-diploma
We are
holders,
not,
Lordship.
we are not claiming equality with them.
This is
Lordship,
our
can
executive
case-
function.
let me-
Time and again, Supreme Court has said, it is
Okay.
executive function.
Okay,
Lordship.
one query.
Lordship,
Is there a qualification of diploma prescribed for this cadre post?
Yes.
for charge
Charge,
mechanic,
not charge mechanic, charge signalman,
Yes, I will show.
judgment signal.
chargeman signal.
Yes.
Is
Uh,
direct recruitment by way of diploma
Yes.
or promotional avenue? You are coming from which cadre, Mr.
Radio mechanic.
Huh?
Radio mechanic.
Radio mechanic, if there is a diploma holder there, is he given accelerated promotion?
For radio mechanic, Lordship, the diploma is not necessary.
Okay, if somebody has a diploma, is he given a accelerated promotion?
That I
Something
have
like
to
that?
take, I have to take instruction to the
True.
Lordship.
Where is the qualification, Mr.
Page 42, the original part. And tight part, Lordship will find it page 39.
Page 40?
39, page 42, a bit unreadable. If Lordship allows me, page 42, chargeman signal,
Page,
serial number 28, page 42.
Hmm.
Chargeman signal, serial number 28. On the Lordship will come to the next page, page 43, serial number 10. Column number 10, promotion failing which from the army on posting or transfer and failing which by direct recruitment. Lordship finds, and on the earlier page, Lordship will find, I'm sorry, not on the earlier page. The diploma part is there. Yes, at page 42, column 7. 3 years recognized diploma in electronic communication,
Yes.
radio engineering. It is there.
If that, show me that decision of the government.
Page 60, my lord, page 60. Page 60.
60.
Yes, my lord.
That's 60. That's a
Para
decision.
7.
Huh?
This is part of the judgment.
Hmm.
Para 7, page 60, para 7.
Hmm.
The bold part. 7.39.22 higher scale has been demanded over the post of overseer in border roads organization on the ground that minimum qualification post is diploma in engineering. The post carries minimum direct recruit qualification of diploma in engineering. These minimum qualifications have been prescribed in 1996. Fifth CPC in their report submitted in 1997 has recommended the scale of 5,000, 8,000 for all posts carrying minimum direct recruit qualifications of diploma in engineering. This is where my case stands.
Yes, Mr. Chakravarti.
Lordship, this is not telling you to, in page 60, I have something.
Page 60, para 7.
Page 60.
60.
So this will be a case you are trying to get it. Come to page 64, Mr.
Yes, my lord.
Para 70.
Page 64.
Last line.
Accordingly, it was recommended the post of overseer would be upgraded and merged with the promotional post of.
No, 64. Internal page, last page, para of the judgment. My Lord Justice Sharma's judgment.
Para 7. That being the position, I am inclined to accept the writ petition granting the aforesaid. Consequently, writ petition allowed by setting aside and quashing the impugned order directing the respondents to extend the benefit of upgraded pay scale to the petitioners. Impugned orders directing the respondents to extend the benefits of pay scale to petitioners who have alternative qualification has been extended to the diploma charge holder mechanic. The respondents shall extend the same to petitioners for the same date from which the diploma charge holder mechanics have been provided with. Benefits which have accrued the petitioners by virtue of the judgment shall be given explicitly. Which
Now show me a statement
my lord,
in your thing
my lord.
that you have that diploma equivalent qualification.
Well, here lordship will also find that even if that post from the judgment has
Read the
Full judgment.
rules minutely once more. Come back. Read the rules. Answer is there. List this matter again on 15 to 2024 for further consideration.
lordship has fixed it on
15 to. And there, because that's a general order, diploma. This court interpreted it, diploma is attracted. In that case, the diploma was given. Here it is not given. So what would be the difference? That's the only thing we have to find it. We'll do it.
with or without
15.
diploma.
But you satisfy me on that you have the alternative qualification as all mentioned in the judgment in paragraph 17.
I'll try to remember. I'll also try to show that without that alternative.
No, no.
That they are also,
It'll not
that
be.
I'll show, my lord.
No, no.
Without the alternative, they'll get it.
This whole case that you're relying on is built on that alternative argument.
I will not argue against that, my lord.
See,
I'll,
and you'll get the answer in that thing you showed me, clause 7, clause 5, clause 6. Those 2 pages. Argue. Yes, next.
Item 43.
Mr. Sharma, you are waiting for which matter?
Item 44.
42? 44.
No need to your words. There are some the grievance of the petitioner that was the senior most teacher.
Yes, Mr. Paul.
Yeah, may I please your lordship?
Got your instruction?
As per our instruction, my lord, as the district scrutiny committee has not recommended the petitioner's name, my lord. That's why we could not provincialize the service of the petitioner, my lord. Here is the instruction, my lord.
Yes, Mr. Decca.
Here already I have NX lordship, Annex 6. District scrutiny committee recommended the teacher who is having lordship.
Okay, we'll consider.
Science graduation lordship.
We consider.
But service is provincialized as a language teacher.
This is
Now,
already.
if we go by the
This is already
language
there.
teacher.
List this matter again on the prayer of the party. List this matter again on 13/2/2024. On that day, we will finish.
Apply, Lord.
Deeply obliged.
Item 44.
The government was asked to publish the original, my lord, service book.
Yes.
My lord, may I pray for a short day, my lord?
Why?
Any counsel, Mr. B. Chaudhary appears for this matter, my lord.
Oh, he is having some medical.
My lord.
Mr. Sharma, Mr. Chaudhary, who is appearing, he is having some medical issues today. In the morning also it was mentioned. We'll have it on a different day.
Yes.
List this matter again on 19/2/2024. On a prayer made for adjournment on behalf of Mr. B. Chaudhary.
Hello, bless, my lord.
Learned counsel for Mr. Is learned standing counsel for?
BTC, my lord.
Learned standing counsel because.
For the private respondent.
Mr. R.M. Decca appears. for
P. Monto.
Mr. R.P. Sharma, senior advocate for petition. Because R.M. Decca.
P.
Private-
Monto, P. Monto.
Sorry, P. Monto for respondent number
5.
5.
Item 45. May I please, your lordship?
In this case, I need some time, my lord, to file affidavit.
On the prayer of Mr. S. Das, this matter again after 3 weeks on a date to be fixed by the registry. In the meantime, the pleadings in the matter be completed by the parties.
Item 46.
May I? My lord, this is my lord covered case. Last occasion, lordship was pleased to direct them to file any response, but no response is filed.
Yes. No affidavit, nothing.
Otherwise, the petitioner's claim is
Not page
for
33,
provincialization
my lord,
after the 2011 Act.
judgment, which has covered this present case also.
No. You have your instructions. You are want to go back to the 2011 Act?
Yes.
Okay. Mr. B. Kaushik, say it's.
My lord.
If you are not serious, we'll have to follow that order. It'll be troublesome.
My lord.
You have your justifications.
My lord.
We'll consider. Mr. B. Kaushik shall invariably on the next date fix, bring on record the stand of the state respondents with regard to the claims made by the petitioner. List again on 26/2/2024.
46-2.
Item 47.
Identical issue. my lord. Identical issue.
Identical.
Oh, same order.
Obliged, lord.
Item 48.
Please, your lordship, in
Yes,
this
Mr.
case, I am not pressing the IA lordship,
Not pressing.
not pressing lordship, because I have been instructed. I am appearing for respond number 5, 6, and 7.
Mr. Adhar, learned counsel appearing for the
Respond number 5, 6, and 7.
respondent number 5, 6, for the applicant oblique respondent number 5, 6, and 7. Praise that he is under instructions not to press the interlocutory application. Accordingly, the interlocutory application stands dismissed as withdrawn. In the writ petition, you write, have you filed the readings are complete? Readings are complete.
No, Lordship, I am representing respondent number 8. Lordship, I have filed my affidavit today, Lordship. Perhaps it is not, it has not come up.
We'll give them some
Lordship, I
time.
have given him
You are
the
protected.
extra copy I have.
Mr. Satra, you are protected. We'll give them some time.
My lord, let him take the time, my lord, but the stay which was about to be granted on the first hearing, my lord, is not granted as of date. And that's why I had filed a petition before your lordship for early hearing, my lord.
Okay, you file your affidavits, whatever your stands are. By 20th, we will have this matter on 22nd.
Lordship, I have already
Right.
filed my affidavit,
You
Lordship.
have filed?
Yes.
Then fine, we'll have it earlier.
Let it be, my lord, on 13th of February. my lord.
30th. On the prayer of the parties, list this matter again on 30, writ petition, no? 13 to 2024. We'll consider on them.
Right, your lord.
Item 49.
Yes, Mr. Bonik.
My lord, in this matter, the petitioner is seeking a correction, in the date of birth. So far as the admit card is concerned, issued by the
That
table.
Meghalaya,
Initially was born in Meghalaya,
we'll consider this. Today it may not be time. We'll consider.
May I
This will
have
have to have
it?
some. consideration.
29, 30th.
No, much matters. We can have it earliest on 7th.
February.
7th.
In my pursuit to address this issue, my lord, I found the development of law quite different.
Kindly please that.
Absolutely.
List this matter again on the prayer of the parties, list this matter again on 7/2.
7.
এইখিনি হলে ওটা বেলেগ দিব মানে
ওলাই চাওক।
এইখিনি শেষ কৰিব দিম।
Wait.
Item 50.
May please, your lordship.
Hmm.
Lordship, I think bring lordship to the, directly to the judgment, your lordship, rendered by the single judge to its effective portion, lordship. Lordship, the matter is, lordship, that I was penalized pursuant to a disciplinary proceeding, where my penalty was stoppage of promotion till my retirement. That was with challenged before the learned single judge. Learned single judge has categorically set aside that particular that penalty, lordship. And during the meantime, lordship, till the judgment was delivered, already 2 years have been lapsed. 3 years has been lapsed, your lordship. And in the meantime, my batchmates were all promoted to the, in fact, my juniors were promoted, lordship, to the higher post. But thereafter, when the judgment, lordship, may read the judgment, your lordship.
15/11/2002.
Yes, lordship.
22.
Yes, lordship. The effective portion is page 81, your lordship.
80?
81. I'll try to be precise, your lordship. Apart from the amongst others provision, lordship, para 30. In case of Vijay Singh versus so-and-so, the apex court has held that punishment not providing the rules cannot be imposed. Accordingly, the penalty of non-consideration of the petition.
Okay, what happened after this?
After this, lordship, what happened, lordship, I filed representation there again and again, lordship, but my promotions were not considered.
No, was any penalty imposed on you after that?
Yes, lordship. After
What?
that, lordship, actually liberty was given by the learned single
Ah,
judge.
that's it.
After that, penalty was given, lordship. It is in page number
87.
90?
90.
90.
90, the effective portion.
Okay.
I do hereby award penalty of.
So
stoppage
this
of
is under
schedule.
challenge before this court.
This is not under challenge, lordship. I have accepted this penalty.
Then?
But what about my promotion, lordship? My
Your promotion will be prospective after the currency of this three increments.
Once the lordship, my humble submission is that once the penalty, that stoppage of promotion till retirement has been categorically said that it is
Fine.
unsustainable.
You show me any law
Exactly.
wherein it says stoppage of 3 annual increments with cumulative effect. On 2/1/23, on 3/1/23, you are entitled to be promoted. Take the order. Give me that law.
Lordship, I'll try to search that authority. Your Honor.
Search it. Search it. That's the answer.
Lordship, that
Just
during
show
the-
me that even if there is a currency of a penalty, you are entitled to be promoted. And that too with effect from the date your juniors were
But
promoted.
my
Just show me
penalty,
that.
my penalty was unsustainable, but it was.
Mr. Das, your proceedings came to an end with
Came to
that penalty. Court interfered with that, but it did not set aside the proceeding. Technically, the proceeding continued till this 23 order. Now you have not challenged it.
Lordship,
That has attained finality. That's the end of the matter.
Lordship, that is my
If
precise.
you want,
point,
I
Lordship.
can immediately clarify that issue for you.
I'll be so grateful, Lordship, but in that.
This is item number,
This is 50.
we can clarify. But research, come back.
Yes, yes, Lordship.
Let him do some research. Is that's your stand basically? Then
Because the punishment is made with effect from 2020, my lord.
be that as it may,
As it-
whenever
as-
the punishment currency is over, you should consider.
Yes.
So, Mr. Read Janakiraman,
Janakiraman.
KV Janakiraman,
Lordship, I have
Read
got
that.
it, Lordship.
read that.
Yes.
Because you have been imposed with a penalty, the earlier everything wiped off. Now, fresh we can direct. If you want that, we can
Lordship,
dispose of this
Speaker,
petition, direct
No,
down afresh.
after the end of the currency of the present,
Present,
petition, she has been promoted, my lord.
Promoted.
One promotion has been
Only one
granted.
post, Lordship, but by.
But in the meantime, her juniors, my lord, they got the next
Your
promotion.
research.
Obliged.
On the prayer of Mr. DJ Das, list this matter again. Heard Mr. DJ Das, learning counsel for the petitioner, also heard Mr. N. Deka, standing counsel,
APDC.
APDC. On the prayer of Mr. DJ Das, list this matter again on 12/2/2024. 12 but board is, you know? Not like it. 15/2/2020. 2024.
Much obliged.
You
Lordship, I.
come up with something.
Yes, Lordship, one
Some
authority.
very big armor
I'll
to
place
blow him off.
more stronger authority. I'll
To
try-
blow him off.
Yes,
Item 51.
My lord, from the counter affidavit, it transfers, my lord, that the action, my lord, which is sought to be taken on the basis of the new regulation, that has not yet, my lord, come into force. So therefore, the regulation, my lord, the impugned,
We'll consider, Mr.
my lord,
Now pleadings are complete.
complete, it will.
List this matter
take
on the
very
prayer of
short
the
time.
parties, list this matter again on 28/2/2024. We'll
Before
cons-
that, my lord. Can it be before that?
All fixed matters are there.
Yes, your lordship will take only 5 minutes time.
Me, it will take hours for me.
No, my lord, I will not argue. I will argue only on 2 points, my lord. Either non-existent fact, my lord, which is based on non-existent fact, and secondly.
21/2/2024.
Obliged. Supplementary for admission 66.
Okay, that relaxation thing. Yes. What to do now?
It was, time was taken for him, my lord, last occasion. Time was taken as he was not there.
My lord, apart from relaxation, my lord, in this case, my lord,
You want to argue this case? Okay, we'll hear. Today, 4 o'clock. List this matter again on. Who is holding the post now?
he is holding.
List this matter again on 26/2/2024.
Obliged. Item 67.
Yes, Mr. Cal,
Affidavit has been, taken with the record.
fine.
Lordship,
Okay. Yes, Mr. Sharma, any
Paragraph-
reply? Any reply to you from you would like? You would like to file any
My
reply?
lord, no, my lord, the query which was made by this honorable court, my lord, whether any action has been taken.
That we
That
have
has
seen
not
on,
been taken admittedly, my lord.
I know that.
That is
Now
why,
we can proceed for disposal. On the prayer of the parties, list this matter again on 5/2/2024. On that day, we will finish. that.
obliged.
And you come, if there is any decisions you can place.
Yes, obliged.
Daily list for orders item 52.
The contempt petition, my lord, the operative portion page 26 onward, para 9, my lord. Second time, my lord, the honorable court passed an order, my lord. Page 26 from onwards, my lord.
2013 school was provincialized, but benefit was not given. Para 9, my lord.
Your services also provincialized.
School was, my service was also provincialized, but salary was not given only because of one dice code 910 is
Here,
not
my
there.
lord.
Honorable could hold that, my lord.
Director asking the standing council to give instructions regarding what have to do. He has not passed any speaking order till that month.
There is no direction for speaking order, just pass order on the above order. Already petition was allowed, madam. Para 11, madam. 11 and 12.
Let's this matter again on 9/2/2024. On that day, Mr. P.K. Bora shall place on record the compliance report in terms of a compliance report towards implementation of the directions contained in the order dated 27/11/2020 passed by this court in 2184 of 2017. 4 years you require, 3 years you require to just pass that order. On that day, if you can't, we will take up.
Item 53.
SK Roy. Yes, Mr. Roy. Yes.
Correction.
Where is the compliance report?
My lord, here, my lord. There, my lord, department probably file a review petition, my lord.
Probably.
My lord, I have to take instruction regarding this, my lord.
Let's this matter again on 29/1/2024. Place that instruction again. On which date Mr. P.K. Bora shall invariably place on record the steps taken for compliance of the directions passed by this court. Otherwise, orders as may be called for would be passed.
My lord, oblige, my lord.
Item 53.
Here I pay for 2 weeks time, my lord. I'm preparing for response number 1, my lord. Is
54.
54, my lord. Is the earlier incumbent, my lord.
Yes. How can I?
But
Today was the last day.
my lord.
Yes.
Hello, last order of this allowance.
Yes, I know that.
54.
54.
Putullah.
Yes, Mr. Kosik. What should I? Yes, Mr. Bora.
Apni Narayanpur.
Order dated 38/2019, right,
I've seen
Mr. Khan?
My
I've
lord,
seen-
order of this honorable court was 24/1/2022. And last order of this honorable court, that is 20/12/2023.
No, I'm not on that. The order
That is
against which violation?
Case 11, Lordship,
No, that's it.
24/1/22.
Huh?
More than 2 years lost.
Yes.
I will fix it on 9th, my lord.
You make an undertaking that you will give the compliance report. Otherwise, I'll not. Call your.
I am appearing for response.
I'm
number-
here till 6 o'clock. Call her.
My lord.
This is not done, mister.
I understand, my lord. But
Is
here-
there anything mind to be applied here? Only a compliance.
I
And for that, you don't know, you let the orders of this court
my lord,
hang like this.
my lord, let this matter be taken up on 9th, my lord. I'll get this.
No. On an undertaking given by Mr. P. Kaushik that he shall place on record the updated status report with regard to compliance of the orders passed by this court. List this matter again on 1/2/2024. 1/2, if not,
My lord. How blessed.
and this thing you tell me at 10:30. We'll call your director at 2 o'clock otherwise.
My lord.
Tell me at 10:30.
My lord.
This orders, these people are hanging. How long will they come to this court? Reject. We have not tied your hands.
Yes, ma'am.
But if you can't take that decision, what is the
Simply a
duty here?
Item 55.
5-1, 5-1, 5-2, Corridor. 5-2/2024.
Item 55 and 56.
I'm sorry, I was supposed to pass this orders today, but
Council has filed the affidavit. The council says, my lord, as an interim measure, they have appointed the petitioner.
Madam.
So let them fill it up, my lord.
that's what. We'll dispose it of directing them. That's what we decided last time.
Let them fill it up.
You'll get the orders next week.
Next week.
Orders next week. I'm disposing it of.
My lord.
Dispose.
My lord, let it come for admission, no?
No,
Madam, you will continue
Yes.
till a decision is.
till a final decision is taken. You will continue. Thereafter, they'll go for a regular process. That much only I'm saying. You are in charge basis now.
Yes, because
My lord, we have already
vacancy
filed.
my lord, in
Okay,
March
madam is having
22.
some objections.
In March 22, it is almost 2 years.
Okay, list this matters again for admissions on when do you want it, ma'am?
Any date.
Convene, you tell me your date. I am here only. You tell me your date.
I'll be.
Second
No,
week
no.
of February, my lord.
Huh?
Second week of February, my lord.
No, not second reason.
My lord, there is a, my lord, EC meeting is there on 6th, my lord. There will be a decision about the district-wise seniority or the school-wise seniority.
Let them
So I
take.
pray
it.
for-
You take it.
My lord,
Place it.
so I have prayed
No,
for the.
no, there
No,
is
no,
no
place it.
problem.
Huh?
Regarding that.
That is your, you
I
please
don't
go
know
ahead.
nothing more.
And I'm
How
telling
is
you,
it-
don't stop your considerations because of presidency of
My
this
lord, my
court.
lord.
List this matter again on 12/2/2024.
That's
Or-
too much.
Fine.
Well,
If ask your junior just to make a mention, we'll, if possible, we'll give you an upgrade. Need not wait for the whole day.
that would be.
Item 57.
We'll dispose it off in that line. Subject to what madam has said.
School wise, I am seniority.
School-wise,
District
my lord,
wise, whoever it's, by the time we'll
on
have
the
that
graduate
decision.
scale
also.
of pay- On the graduate scale of pay, the petitioner, he is a senior, my lord, not by my lord.
Whatever you have your decisions, place that
My
also.
lord.
57.
Yes,
Last order, my kind.
yes, Mr. Fukan, what
Yes,
happened?
In this matter, we are filing a writ appeal. A matter can be, may not be, have it in the next week, Lordship. What has happened is our names are not shown also, Lordship. We're filing a wakalatama as well. It's come, I think, for the,
No, I had asked Mr. Katonia to place the instruction.
Lordship, because our
4/12,
names are not shown.
4/12,
My lord, so you can't appear otherwise, Lordship.
4/12, 22/1.
It's a contempt matter, Lordship.
How many times? Huh? Why this order is not being complied with?
Lordship, the 2023 matter, Lordship, will allow us to file a wakalatama. In the meantime, we'll.
No, no, no. You have been issued notice much before this.
Uh,
Hmm,
Some, my lord, for today, Lordship, may fix it in the next week, Lordship. In the meantime, we'll get our instruction, my lord.
in the event, the instructions are sought for, why the orders dated 4/12/23 and reiterated on 22/1/2024 is not placed on record by the next date fixed. The director, Elementary Education Assam, shall be required to be present before this court at 2 p.m. on that day. So, the Learned Standing Council, Elementary Education, Mr. A. Fukan shall make a mention of this matter at 10:30 and apprise this court as to whether the instructions have been furnished to him. 10:30,
On
the registry to reflect the name of Mr. A. Fukan, Standing Council, Elementary Education, in the cause list.
my lord, on which day, my lord?
On Kimanta Igdilu? Reddy Anani. 8/2, 7/2.
Right.
If you have filed appeal, bring the stay order. Enough.
Right.
We'll ask Mr. Sinha to take rest. If not, 10:30, you are making that mention.
My
for me.
deeply obliged.
Item 58.
There is a limit, Mr. Fukan, there is a limit.
Yeah.
Yes, madam.
So instructions were so.
Yes, no instructions. What happened?
I have received the instruction and here, my lord, the petitioner has unauthorizedly absent, so no pay has been, this is then.
I'll go through it once. You're here, you are going out somewhere.
I'll be going after some. It's okay, Lordship
Okay.
may fix.
12th, can I fix it?
No.
List this matter again. Mr. Yu Sharma, in terms of the earlier order has passed, has brought on record. Communication dated 25/1/2024. A copy thereof no, which brought on record, has furnished a communication dated 25/1/2024. List this matter again on 12/2/2024.
Yes.
The copy of the communication dated 25/1/2024 along with its enclosures is kept on record and marked as X. We'll see.
Item 59.
Lordship, this is a medical reimbursement case.
Lordship,
here I have informed that the department is seeking some more time to
Okay.
process the claim. I
Let
have-
him have it.
Lordship.
Let him have some time. He's asking some
They're-
time.
Lordship, they're just.
Last chance, Lordship.
No, 23 matter.
Lordship, but they are
Uh,
sitting on it. Lord.
On the prayer of Mr. A. Chalia, Learned Standing Council,
Health and Family.
Health
Welfare
and Family Welfare Department lists this matter after 3 weeks. So he shall, Mr. Chalia shall on the next day place on record the instructions with regard to the claims made by the petitioner in the petition. List this matter again on 26/2/2020.
Lordship.
You bring it,
Lordship, Lordship, it's under process only. They're asking for some time there.
they'll do it.
Item 68.
एक नया से Yeah, well,
Lordship, may I please, Lordship, I'm appearing on behalf of respondent number 6. Lordship, today I have filed the wakalatnama.
on the prayer made by Mr.
Jay Firdaus.
J. Fidus, Learned Council appearing for the respond number
6.
6.
Yes, Lordship.
What is your name, madam?
Adam.
R. Dotto. Miss R. Dotto, MS R. Dotto for the
Take
petition.
fresh step to the respondent number 7, my lord.
Huh?
We will take fresh
Okay.
step to the
Miss P. Dotto,
Adam.
R. Dotto for the Learned Council for the petitioner. Also heard Mr. F. Fidus.
Jay
J.
Firdaus.
Fidus.
Jay Firdaus.
Learned Council appearing for the respond number 6. Full stop. Seen the office note. Seen the office note dated 10/10/2023. No. Oh, you have not taken fresh steps, madam. 24/1.
Respondent number 7.
Okay. Seen the office note dated 24/1/2024. Petitioner was to take fresh steps for service upon notice on respondent number 6 and 7. However, respondent number 7 has entered appearance through Mr. J. Fidus, advocate. Full stop. Accordingly, the petitioner is granted 2 days time to granted a week's time to take steps for service of notice upon respondent number 7. List this matter after 4 weeks with a report regarding the status of service of notice upon the respondent number 7. In the meantime, the other respondents may bring on record their respective stands by way of filing affidavits.
Yes.
Done.
Item 61 for hearing.
Hello.
Yes.
Hello, I am returning from service in the month of March, my lord. I am there for consideration for promotion to the next higher post of.
Okay, we'll do that. Now you can do it relaxedly.
Lordship, any other day? Any other day, Lordship? Today, Lordship?
No, he is retired.
March, Lordship.
That's it.
In the.
Yes, Mr. Sharma, what do you want?
Whoever is there, Lordship.
What do you want?
Consideration for promotion, my lord.
Now, okay.
My lord, my second promotion.
You consider prospectively from today.
Lordship.
I'll direct that. He wants that, I'll direct that.
Lordship, any other day,
Some
Lordship?
other parts. Next week, any date, my lord.
Come by, sir.
Heard the parties to the proceedings. On the prayer made by the parties, list this matter again on 26
Lordship. That earlier, my lord.
to 19/2/2024. 19.
7 or 8.
Even if I direct, do you think they'll promote you in weeks' time? You're holding the charge.
Pendency shall not be a bar.
No.
Consider, my lord. My promotion is due from 1st January, my lord.
1st January, I know.
Yes.
You have come here, we will consider, don't worry. Councillor, have they exercised, they taken any steps for recruitment, promotion, exercise? Then
It is single cadre post.
May I please your lordship?
19th, yes.
Lordship, I have a small prayer regarding item number 48. Lordship, I have taken the concept of consent of Abdul Sattar sir. Lordship has fixed the matter on 13th of February. Lordship, I will be out of station for medical treatment, Lordship. Can it be fixed on Lordship 24th? Sir has also given the consent.
24,
24.
item number?
Item number 48, Lordship.
48.
48.
24 holiday,
48, 24 holiday.
Any date after
26.
26?
Lordship. Lordship and Lordship for respondent number 8, I am representing respondent number 8. Lordship, the name of Mr. V. Deka is shown. V. Deka is not associated with this case anymore. So can his name?
That, whenever the matter is called up.
Lordship.
This much I am